And we are live. We may begin at your leisure.
Terrific. Welcome to Courtroom 4. We are about to begin the trial. I'm going to ask each side if they are ready to proceed. Counsel for the prosecution, are you ready to proceed?
Yes, Your Honor. And
counsel for defense, are you ready to proceed?
Yes, Your Honor.
Both sides having announced ready, I'm going to ask each side to introduce the participants in today's round, starting with the prosecution.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Emma Senishin. Today, my co-counsel and I represent the prosecution. If my co-counsel could go ahead and introduce themselves.
Good morning, Your Honor, members of the jury. My name is Alexandra May.
Good morning, Your Honor, members of the jury. My name is Lily Humber. May our witnesses introduce themselves?
Of course, Your Honor. Of course.
Good morning, Your Honor. My name is Lola Fakes, and I am Alex Cifuentes.
Good morning, Your Honor. My name is Carolyn Johnson, and I am Kyle Kuzak.
Good morning, Your Honor. My name is Tess Hayden, and I am Jordan Markowitz.
Thank you. And counsel for defense and witnesses, can you please introduce yourselves?
Good morning, Your Honor, opposing counsel and members of the jury. My name is Michael Dudzik, and today, along with my co-counsel, we represent the defendant, Ms. Avery Becker. Today, I will be conducting the direct examination of Professor Blake Van Owen, the cross-examination of Kyle Kuzak, as well as delivering the closing arguments. Your Honor, at this time, may my co-counsel introduce themselves?
Yes, please.
Good morning, Your Honor. My name is Ella Damon. I will be delivering the opening statement as well as conducting the direct examination of Taylor Perkins and the cross-examination of Alex Cifuentes.
Good morning. My name is Anna Seaman, and today I will be conducting the direct examination of Avery Becker and the cross-examination of Detective Jordan Markowitz. Permission for our witnesses to introduce themselves?
Yes, please.
Good morning, Your Honor. My name is Octavia Gomez, and I am Avery Becker.
Morning, Your Honor. My name is Maisie Bogich, and I am Taylor Perkins.
Good morning. My name is Thomas Daneza, and I am Professor Blake Van Owen.
Thank you, everyone. At this time, I will swear in the team members and the witnesses and our scoring panelists, starting with the team members. If you could all flick on your video and raise your right hands. Team members, do you promise that the presentations you are about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition?
Yes, Your Honor.
Yes,
Your Honor. Yes, Your Honor.
And witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
And for our scoring panelists, if you can raise your hands, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Everyone having been sworn, I believe we are ready to begin. Before we start, are there any preliminary matters that either counsel would like to raise, starting with prosecution?
Yes, Your Honor. We have 3 housekeeping matters at this time. First, we request to reserve any time not used in our closing argument for a rebuttal.
Thank you. That will be allowed, and I'm going to ask our timekeepers when we get to that point to let me know how much time has been reserved after the completion of the prosecution's opening segment of closing argument. Next, you said you had 3?
Yes, Your Honor. Second, there are stipulated facts that have been agreed to before the trial today, and we request that these are constructively read into the record.
I was hoping someone would raise that. Yes, the court has received those stipulations, and they will be entered into the record and constructively provided to our panelists. I believe they've already seen them. Third?
Thank you, Your Honor. Finally, When we enter exhibits during the trial today, we intend to screen share the exhibit at the onset of the questioning of the witness. We would then proceed with entering the exhibit into evidence, and it would be formally admitted by Your Honor. Would this be acceptable?
Sure, that's fine.
We have no further housekeeping matters. Thank you.
Any preliminary matters from the defense?
Briefly, Your Honor, the defense would just like to confirm that once exhibits are shared on the screen, they're constructively hidden from the jury's view until Your Honor has admitted them into evidence.
That's the understood procedure. Yes, thank you.
No further from the defense then.
All right. One thing I will mention, just so everyone is clear, with respect to jury instructions and the timing of the constructive giving of the jury instructions, it would be the court's preference, unless somebody disagrees with that, to constructively give them before closing arguments begin, so that it would be my expectation that some of you may be interested in referencing the jury instructions in your argument, so you'll be allowed to do that because the instructions will have been given before you begin that. Anything else from the prosecution?
No, Your Honor. Thank you.
And anything else from the defense before we begin?
No, Your Honor.
All right. Prosecution may begin its opening statement.
Thank you, Your Honor. Mischief was intended, in murder it ended. Good morning, Your Honor, members of the jury and opposing counsel. My name is Alexandra May, and along with my co-counsel, Ms. Emma Senishin and Ms. Lillian Humber, we represent the people of Colorado. We are here today to provide the story of March 6th, 2020, the day that Mr. Mackenzie Brackman's life was taken far too soon. Mr. Brackman was a mock trial coach at Colorado High School, volunteering his time to provide coaching to kids in order to allow their love for mock trial to continue to grow. Let me tell you a story, the story of Miss Avery Becker. It's 3 o'clock on a Thursday, and Miss Becker has just gotten home from school. She storms into the kitchen and throws her backpack down in rage. You see, after putting countless hours of work into mock trial, her coach, Mr. Brackman, continues to belittle her efforts. Their fighting is growing and the tension's increasing. So much so that Avery takes a permanent marker and writes on the hood of Mr. Brackman's car, "Worst Attorney Award." But that's not enough. As she hides away the Sharpie, she pulls out her phone, texting her friend Alex, laying out her intent to break into Mr. Brackman's home and vandalize his belongings. Avery's eyes are tearful with anger as her mom walks into the kitchen to ask what's going on, to which the defendant responds, "I will get back at him if it is the last thing I do." The defense will call 3 witnesses to the stand today. They will call Ms. Taylor Perkins to the stand, Avery's best friend, who stepped down from the mock trial team in order to benefit the defendant, and is also the defendant's only alibi for the day of the murder. What else is Ms. Perkins willing to do for her best friend? They will call Mr. Van Owen to the stand, who quit his job in the field directly relating to the field that he's testifying as an expert in today. And they will call the defendant, Miss Avery Becker, to the stand. This is not Miss Becker's first time on the stand, though. You see, she did mock trial and was quite good at it. One might say she had a way of swaying the jury. Miss Becker was not at school the day of the murder, and her only alibi is her best friend. The prosecution will also call 3 witnesses to the stand today. We will call Miss Alex Cifuentes to the stand, who will testify to her great relationship with the defendant through their time at mock trial, and will testify to the tension and fighting she saw between the defendant and the victim. We will call Ms. Kyle Cusack to the stand, an expert in crime scene reconstruction, who collected the evidence from the day of March 6th, meticulously constructed a timeline which placed a perpetrator of the same height and build as the defendant breaking into Mr. Brackman's house and stabbing him in the back with a knife. And last, we will call Detective Jordan Markowitz to the stand, an expert in cell data tower analysis, who collected the cell towers from the day of March 6, 2020. These cell towers placed the defendant's phone pinging off of a cell phone tower in direct proximity to Mr. Brackman's house. The prosecution holds the entire burden of proof today, but you will see that we will prove beyond a reasonable doubt that Miss Avery Becker is guilty of second-degree burglary of a dwelling and murder in the first degree. At the end of the trial today, my co-counsel, Ms. Lillian Humber, will summarize the evidence we've provided to you today. And you will see that we've provided mountains of evidence for you to make a ruling in favor of the people of Colorado. Your Honor, members of the jury, as the trial goes on today, I ask you to keep a simple phrase in mind. Mischief was intended. In murder, it ended. Thank you.
Thank you, counsel. Counsel for the defense, opening statement, please.
May it please the court. I'm Ella Damon, along with my co-counsel. We represent Miss Avery Becker. Prosecution just told you this case is about the mischief Avery Becker had, resulting in murder. It's not. It's about a careless and clumsy investigation by the Denver Police Department, making a mockery of justice. The victim, Mackenzie Brackman, coached a Colorado high school mock trial team. Mock trial is a pretend competition where students act as lawyers and witnesses, similar to what you will see today. But there are no consequences if you lose mock trial. No one's life is on the line in mock trial like Avery Becker is today. Avery Becker last year was a senior and it was her 4th year on the team. She is talented and smart, had bright plans for her future. She would not jeopardize this future for an extracurricular activity. Avery Becker and Coach Brackman had a complicated relationship. They both needed each other to succeed in mock trial, but they didn't particularly like each other. You will hear about the constant criticism Coach Brackman dished to Miss Becker in practice, but mock trial was easy for her. She was a natural, and Coach Brackman resented that. The evidence will show at last year's regional mock trial tournament, Miss Becker won 2 awards. Coach Brackman became even more irritated and said some deplorable things to her, and Miss Becker, who was still just a high school student, was upset. She took a marker and wrote on his car. A childish mistake, and she felt horrible about it. She apologized, but Coach Brackman wouldn't have it and threw her off the team. Now, although Miss Becker will tell you she was upset, she was not angry enough to murder her coach. She wouldn't throw away her entire future over participating in mock trial. The evidence will show the night before Coach Brackman died, March 5th, 2020, Miss Becker and her best friend Taylor Perkins went to the Fry Shack. The next morning, Miss Becker will tell you how she realized she had lost her phone, so she, Miss Perkins, skipped school that day and drove around looking for it. Miss Perkins will tell you she was with the defendant, Avery Becker, the entire day. Now, prosecution claims to trace Miss Becker's location using cell phone geolocation data by pinging off various cell phone towers, but you will see a gaping hole in that evidence. First, cell phone data only shows where a cell phone is within a wide range, not the exact location of the cell phone. Second, the data only shows where a cell phone is within a wide radius, not who has possession of the cell phone. Miss Becker did not have her phone on her person March 6, 2020. Someone else must have. In addition to hearing from Ms. Perkins and Ms. Becker, you will hear from Professor Blake Van Ohm, whose expertise is crime scene reconstruction, cell phone tower analysis, and police investigations. Professor Blake Van Ohm will explain the prosecution's theory of Coach Brackman's murder is inconsistent with the evidence. He will explain how investigator Kyle Cusack's photographs were conveniently corrupted. The victim is photographed without shoes, but somehow made scuff marks in an altercation with the perpetrator. The prosecution claims the knife that killed Coach Brackman came from a block of knives, but the murder weapon's handle doesn't match the knives in the knife block. Detective Markowitz will testify about how the investigation process was conducted, but listen carefully, because more important than what was done is what wasn't done. The prosecution just told you you will see text messages between Miss Becker and another mocker, Alex Fuentes. But Detective Markowitz only received and relied on screenshots of these alleged texts and didn't look at the actual cell phone. Nor did Detective Markowitz receive or request phone data from Miss Perkins' phone to confirm Miss Becker's alibi. Ms. Becker and Ms. Perkins' phone data was simply ignored unless it appeared to the benefit of the prosecution. But the biggest mockery of justice, Professor Blake Van Owen will explain, is that Detective Markowitz zeroed in on one suspect, Avery Becker, from the get-go. She didn't entertain any other possible suspects, such as Blair Rollins, whose father is in jail because Coach Brackman lost his criminal trial. Avery Becker is charged with 2 crimes, first-degree murder and second-degree burglary. Because the prosecution has burden of proof, it must prove every element of these charges beyond a reasonable doubt. At the close of evidence, you will see the only way to stop this mockery of justice is if you find Ms. Becker not guilty.
Thank you, counsel. The prosecution may call its first witness, and who will that be?
Thank you, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Thank you.
May
Ms.
we proceed?
Cifuentes, you'll recall that you're still under oath. You
Yes,
may
Your
proceed,
Honor.
counsel.
Good afternoon. Please introduce yourself to the jury.
Yes, my name is Alex Cifuentes. That's Sifuentes.
Alex, how old are you?
I'm currently 17. I'm a senior at Colorado High School. Go Eagles.
CHS, what kind of activities are you involved in?
Well, I recently joined the Ping Pong Amateurs Club, but my favorite and by far most time-consuming activity is certainly mock trial.
Could you tell the jury about your involvement in mock trial?
Yeah, so I've done mock trial all 4 years of high school. I'm usually an attorney. I love it. I spent a lot of time in it. I would always await the day that our coaches would assign roles, and I'd go home and dig right into the case.
Do you see anyone here today who did mock trial with you?
Yes, I saw Taylor Perkins and Avery Becker.
Were you friends with the defendant?
I would say so. You know, we did mock trial all 3 years that she was on the team. She was a grade above me. You know, we spent so much time together on mock trial. We became really close. She was the one to introduce me to mock trial in the first place.
What was the defendant like on the team?
She was a really good witness. You know, she was very good at mock trial, very talented. She had just this amazing ability on the stand to sway the jury any way she needed to. You know, it was unbelievable watching her.
Objection, improper character evidence. Move to strike.
Permission to respond?
Yes, response.
Your Honor, this evidence is not being offered to prove that on a particular date the defendant acted in accordance with such trait, rather to lay foundation for the animosity between the defendant and Mackenzie Brackman and the motive of the defendant.
Any reply?
Yes, Your Honor, under Rule 404, evidence of a person's character or character trait is not admissible to prove that on a particular occasion that person acted in accordance with that character trait. Ms. Fuentes just stated that Avery Becker had ability to sway the jury. Opposing counsel is trying to prove that because she could sway the jury at that time, she would go as far to be able to manipulate the jury today, which is improper character evidence.
Thank you, counsel. The court will allow the testimony. The evidence doesn't yet get to the point where it's being offered to prove propensity to act in this manner. So please proceed, but be mindful of Rule 404.
Absolutely, Your Honor. Did you get to finish your statement, Ms. Cifuentes?
I'll keep going. You know, like I said, really good actress. I didn't, though, appreciate, you know, her work ethic. She would show up late to practice. She, you know, she wouldn't really prepare for competitions, and I didn't like the way that she treated our coach at all.
How did she treat your coach?
You know, she would just refute his advice, ignore his edits. You know, he was a criminal attorney. Like, that was what his job was. He did that for a living, and she just would ignore everything he said. One day she showed up to practice completely unprepared, really obviously had nothing ready, and he demoted her to B team for that.
Did she react to this demotion in any way?
She threw a fit, like an absolute fit. But at that point, if a team had lost another member, we probably weren't going to be able to compete in regionals. So her really good friend, Taylor Perkins, who was on A team, quit the team. So Avery had to be let back on A team, but she wasn't on the team for much longer than that.
Well, how come she wasn't on the team for much longer?
There was one practice where it was after the regional tournament. She had won some awards, though, at the tournament, she kind of flew off script. She made things up on the spot and she didn't really stick to our plan. And Coach Brackman kind of got on her about that, saying, you can't just walk into a trial unprepared, expecting your client to become acquitted. That's malpractice in the real world. And that her awards weren't really well deserved. And she left practice with a Sharpie in her hand, fuming.
Well, what did she do with the Sharpie?
She went to the parking lot, got on Mr. Brackman's super, super sweet 911 Porsche and wrote in big black permanent letters, worst attorney award.
Objection, improper character evidence.
Your response?
Your Honor, this is not being offered to show that the defendant acted in accordance with this behavior on a particular occasion. It's rather to provide evidence of the animosity between Mackenzie Brackman and the defendant.
Reply?
Yes, Your Honor. Under Rule 404B1, evidence of a crime, wrong, or other act is not admissible to prove a person's character or character trait in order to show that on a particular occasion, that person acted in accordance with that character trait. The opposing counsel is trying to show that because this vandalism occurred, that Ms. Becker go as far to go to Coach Brackman's house and vandalize it, resulting in his murder.
Court finds that the evidence actually goes to motive, and so it's admissible. Counsel, you may proceed.
Yes, Your Honor. Ms. Cifuentes, to your knowledge, did Mr. Brackman ever press charges for this?
Not that I know of. He was murdered so soon after the incident. All I know is that she got kicked off the team for good this time.
To your knowledge, did the defendant accept this punishment?
Absolutely not. She was texting me and other team members trying to get them to talk to Mr. Brackman to help get her back on the team.
Your Honor, permission to present this witness with Exhibit 14?
You may proceed, yes.
Ms. Cifuentes, do you recognize this exhibit?
Yes, I do.
What are these?
These are screenshots of text messages between Avery and I. These are the screenshots that I sent to the detective.
How do you know?
I texted Avery. I was a part of this conversation, and I took the screenshots myself from my phone.
Is it a fair and accurate representation?
Yes.
Your Honor, we move to enter Exhibit 14 into evidence.
Any response?
Yes, Your Honor. I object to hearsay, lack of foundation, authenticity, and best evidence.
Any reply?
Yes, Your Honor. With respect to hearsay, pursuant to the rules 801D1 and 801D2, the statements here in these screenshots are made by the party opponent and by the person currently testifying, in this case, Alex Cifuentes. With respect to authenticity, Your Honor, we are moving to enter this exhibit with the truth of it being a screenshot. Any issues with authenticity of the messages themselves can be addressed within the scope of cross. Additionally, 2 expert witnesses today can testify to the authenticity of the message. However, if the defense has an issue with Ms. Cifuentes' personal knowledge, I'm happy to lay more foundation.
Any reply?
Yes, Your Honor. The opposing counsel has not laid enough foundation to show that Ms. Becker did send these text messages. In fact, it is the defense's theory that Ms. Becker did not send these text messages, which means the authenticity is in question, which it cannot be used as a duplicate, as these are screenshots of the text messages.
With respect to the hearsay issue, the court finds that these are statements of a party opponent and so are admissible in that regard. With respect to foundation, counsel, could you lay a little bit more foundation about the origin of these text messages, i.e. that they did in fact originate from Avery Becker?
Absolutely. Ms. Cifuentes, was this a real conversation between you and Avery?
Yes.
Take your time to look through. Do you have recollection of sending the messages in green?
Yes, I sent all of those messages.
And take your time again. Do you have recollection of receiving the gray messages from Avery Becker?
Yes.
Did you fabricate or alter these messages in any way?
No, these are exactly what they looked like on my phone as I took the screenshot.
Your Honor, we move to enter Exhibit 14 into evidence.
Any objection?
Yes, Your Honor, I still object to best evidence and authenticity, as well as,
The court, I'm sorry.
excuse me, as well as hearsay.
Okay. Court's already addressed the hearsay objection, and the court finds that sufficient foundation has been laid to establish authenticity of this the series of text messages. So the court will allow the evidence. Counsel, you may proceed.
Ms. Cifuentes, could you give the jury the summary of the defendant's request?
Yeah, is it okay if I annotate the screen?
Your Honor, permission for this witness to annotate the document?
You can do that, sure.
So basically here, she says that she's pretty desperate to get back on the team. And then she says, is there any way you'd be willing to talk to Coach Bracken about having me back?
Did you ever talk to Coach Brackman?
Yes, I did. At that point, without Avery, we probably weren't going to do well at state. And we might not have been able to go to state without her. So I made a big plea to Mr. Brackman to let her back on just so we could go to state. But he completely shut me down, which I told her here that, I doubt anyone could change his mind.
What did she say next in response to this?
She said, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
I see. And did you ask what she meant by that?
Yes, I said, what are you going to do to his house? And then she said, I'm going to wait until he's at work, then break in and trash it, referring to his house.
Thank you, Ms. Cifuentes. Ms. Bennett-Spurlock, you can stop sharing the screen now. Ms. Cifuentes, did you see the defendant on March 6th?
No, Avery wasn't at school that day. I have some classes with her and she wasn't there. The next thing I know, Mr. Brackman had been murdered.
Thank you, Ms. Cifuentes. Your Honor, no further questions at this time.
Thank you, counsel. Cross-examination.
Yes, Your Honor. Ms. Cifuentes, you said that you were good friends with Ms. Becker.
Yes.
But you never hung out with her outside of mock trial, did you?
There was no reason to. Mock trial was kind of our lives.
Is that a yes or no to my question?
No, we usually hung out in mock trial and at mock trial related events.
In fact, you were jealous of her.
I wouldn't say I was jealous of Avery.
You were excited for the larger roles you would receive with Miss Becker off the team, weren't you?
Of course I was, especially when she would graduate. I was excited to kind of assume her roles.
In fact, you were the one who would benefit most with Miss Becker off the team.
I would say the whole team would benefit with her off the team.
I now want to ask you about text messages you say you received from Miss Becker. Please show Exhibit 14 on the screen, which has been previously admitted. Miss Becker's name is listed at the top, isn't it?
Yeah.
But there is no phone number listed for her name, is there?
No, I have her contact in my phone, so it shows her contact.
There are also no date or timestamps indicating when each text was sent or received, are there?
No.
That's because these texts aren't real, are they?
No, these texts are real.
Did you take the text that Miss Becker allegedly sent to you seriously?
What do you mean?
Did you take the text that Miss Becker allegedly sent to you seriously?
I mean, about trashing his house, I didn't think she was stupid enough to actually do that. So I didn't take them that seriously, no.
You didn't take them seriously because Miss Becker never sent these.
No, she sent them.
If these texts were real, you would have contacted the police. It was possible Coach Brackman's house be broken into, but you didn't do that.
As I told you, I didn't think Avery was stupid enough to actually do that.
Is that a yes or no to my question?
Could you repeat your question?
You didn't contact the police about this possible vandalism threat, did you?
No, I didn't contact the police.
I now want to ask you about your interview with Detective Markowitz. You completely forgot to bring your phone to the police station?
No, my phone's battery wasn't working very well, so I left it home charging.
So Detective Markowitz never looked at the original copy of the text, did she?
Detective Markowitz did look at the original copy. I provided her with the original copy.
She didn't look at the actual cell phone though, did she?
No, she didn't look at my phone.
She only looked at screenshots you took and you sent to her.
Yes, she did.
But that's okay because you didn't want the police to examine your phone, did you?
No, I offered to bring my phone in.
You have a new phone now, don't you?
Yeah, like I said, the battery was going bad, so I got a new phone about 3 months ago.
You got rid of the original phone with the original text on it.
I don't have that phone anymore now.
And you have no idea where that phone is right now, do you?
No, I have a new one.
So isn't it true the defense has never had an opportunity to see if these texts were real?
I don't really know what you mean by that. These are the real texts. I'm not sure what you're asking.
Because you have no idea where that phone is right now, do you?
No.
Let's move on to another student at CHS. Do you know of a person named Blair Rollins?
I know of Blair Rollins, yeah.
You went to Colorado High School with him. You were classmates.
I don't think I was in any classes with Blair, but I know of them.
But you went to you went to high school at Colorado High School with Blair at the same time.
Yes, we both went to Colorado High School at the same time.
You were aware that Coach Brackman represented Blair Rollins' father in this criminal trial.
No, I was not aware of that.
But you were aware that Coach Brackman represented students' fathers at Colorado High School.
I know that Mr. Brackman represented a Colorado High School student, but I didn't know of it being Blair Rollins.
On March 5th, 2020, you were at the Fry Shack, weren't you?
Yeah, I was with the mock trial team for a post-practice snack.
You saw Miss Becker there.
Yeah, she was with Taylor.
You two talked how she should move forward from the team.
Yeah, we did. She
She even thanked you for this advice.
did.
So as of March 5th, she didn't seem to have any angry or bitter feelings about mock trial at all, did she?
I wouldn't say that. I think she didn't have any bitter or angry feelings toward me. She thanked me for talking to Mr. Brackman on her behalf.
But she seemed to have moved on from mock trial at that point.
I have no idea if she moved on from mock trial or not. She still seemed pretty frustrated about getting kicked off the team.
You had possession of Miss Becker's phone that night, didn't you?
Yeah, she let me play a game on her phone for a little bit.
You had possession of Miss Becker's phone right before it went missing, didn't you?
I didn't know that it went missing, but yes, sure.
No further questions, Your Honor.
Thank you, counsel. Any redirect?
Briefly, Your Honor.
Okay, you may proceed.
Ms. Fuentes, when you were called in by Detective Markowitz, where was your phone?
It was at home charging. Like I said, the battery was going bad and it wasn't holding a charge, and why bring a dead phone to an interview anyways?
I see. And when Detective Markowitz asked for screenshots, what did you do?
I took screenshots of my phone and emailed them to the detective. I offered to bring my phone, but it wasn't necessary. The screenshots were completely enough.
Thank you, Ms. Fuentes. Your Honor, no further questions.
Thank you, counsel. Any recross?
No, Your Honor.
Thank you. Witness may step down. Prosecution may call its next witness.
Your Honor, the prosecution would like to call Ms. Kyle Kuzak to the stand at this time.
Thank you. Ms. Kuzak, you'll recall that you are still under oath.
Yes, Your Honor.
Counsel, you may proceed.
Thank you. Ms. Kuzak, could you please state your full name and spell your last for the written record?
Kyle Kuzak, Kuzak.
What do you do for a living?
I'm a Colorado Bureau of Investigation Certified Crime Scene Reconstructor, or a CSR.
How long have you been doing this job?
19 years.
And what exactly does this job entail?
I investigate all sorts of complex crimes, including home invasions, burglaries, and other property crimes, domestic violence, fatal accidents, and armed robberies.
Who do you work for, Ms. Kuzak?
I work for the city of Denver, and I have for the past 3 years.
Your Honor, pursuant to Rule 702, I now move to enter this witness as an expert in crime scene reconstruction.
Any response?
Yes, Your Honor. May I perform a brief what here?
Briefly, yes, counsel.
Ms. Kuzak, you just testified that you were board certified over 19 years ago, correct?
Yes.
And you never mentioned any training of how you got board certified, did you?
My training is the 19 years in this field.
And after you were board certified, you don't mention any more recurrent training in the field of crime scene reconstruction, do you?
No, like I said, I work in this field every day, so my training is these 19 years of
So,
experience.
Ms. Cusack, that's a no to my question.
No, it didn't include any extra training because this is my training.
Your Honor, at this time, the defense objects to Ms. Kyle Cusack being entered as an expert witness pursuant to Rule 702.
Thank you. Counsel, any response?
Yes, pursuant to Rule 702, an expert only needs to be proficient in one of the fields of knowledge, skill, experience, training, or education. And if one of these is true, they may testify as an expert. Ms. Cusack has testified to her extensive background in this field, and with 19 years of background, she also has skill in this field. So I do believe Ms. Cusack has presented the proper qualifications in order to testify as an expert in crime scene reconstruction.
Any reply, counsel?
Yes, Your Honor. Your Honor, pursuant to Rule 702, notwithstanding the technical requirements laid out in the rule, Your Honor, as the gatekeeper, has the job of allowing experts to be testified in certain fields. Given the fact that Ms. Cusack has not testified to how her expertises in the past relate to the case today, and her lack of testimony in a court of law, she should not be qualified or tendered as an expert witness in today's case.
Counsel, can you lay a little bit more foundation as to credentials and qualifications for this witness?
Yes, Your Honor. Ms. Cusack, can you please repeat for us what exactly a crime scene reconstructor does?
Yeah, so a crime scene reconstructor takes all the evidence from any case and tries to place it together in a 5-step process that I will get into later. It's a very complex process, but I take it very seriously.
Could you tell us those 5 steps?
Yes, it's recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and finally reconstruction. And I use these 5 steps in every case.
Did you use those 5 steps in this case today?
I did.
Your Honor, I now move to enter this witness as an expert in crime scene reconstruction as she has presented how she goes about conducting crime scenes and how she has gone about conducting crime scene reconstruction in past investigations, and has stated that she did go about these steps in order to reconstruct the crime scene today.
Counsel, any response?
Your Honor, her methods of conducting a crime scene pursuant to Rule 702 and as an expert still don't matter to today's case because they don't relate to the facts at hand. Ms. Cusack and opposing counsel have not laid the proper foundation that she can testify about the specific facts of today's case pursuant to Rule 702.
Any reply?
Yes, Your Honor. I do believe when Ms. Cusack was saying that in investigating these crime scenes, she goes through the 5 steps of recognition, documentation, and collection of evidence, evaluation of evidence, hypothesis and testing, and reconstruction. I believe she's gathered all the facts from that in order to properly testify to the case today, as she did state that she went through all these 5 steps, in collecting and reconstructing today's case.
Any brief reply, counsel?
Yes, Your Honor. Again, going through her 5-step process does not allow us to know what kind of cases she's testified about in the past. If she's ever been qualified as an expert witness on the stand before, she is simply not qualified, Your Honor.
The court finds as to qualifications and credentials that under Rule 702, which only requires knowledge, education, training, or experience, the 19 years of experience plus certification suffices to meet that threshold. As to methodology, Rule 702, as interpreted in this state, only requires reasonably reliable methods, and the process that the witness has described that she followed here qualifies for that. So the court will accept this testimony as coming from an expert witness and allow opinions to be given. Counsel for prosecution, you may proceed.
Thank you. Ms. Cusack, what's your involvement with the case here today?
I was called to visit the scene at 444 South Flower Street.
Whose house is this?
Mackenzie Brackman's.
Were you able to identify the victim there as Mr. Mackenzie Brackman?
Yes, I was.
So other than visiting the crime scene for this case, did you do any other work?
Yes, I also reviewed all the police reports in this case, all of the evidence, the 4 ring security camera videos, and the autopsy.
With your experienced background in this field, how do you typically go about conducting your investigations?
I first assume that every case is going to trial, so I conduct a thorough investigation accordingly. And starting from day one, I memorialize, document, and organize all of my evidence with a mindset of future reconstruction.
What's the benefit of conducting your work this way?
This ensures that I have an accurate and efficient flow of my CSR work, which I approach in the 5-step process that I just mentioned.
And Ms. Cusack, would you be able to briefly restate those 5 steps for us, just for the jury members?
Absolutely. Recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and finally, reconstruction.
Did you go through all those steps in today's case?
I did, yes.
So after gathering all the evidence from this case, what conclusion did the evidence ultimately lead you to?
The ring security videos exhibit a perpetrator matching the general height and build of the defendant, Avery Becker, approaching the victim's residence and breaking in.
Your Honor, permission to screen share what has been previously marked as Exhibit 12 so my witness may view it.
So granted.
Ms. Bennett Spurlock, may you please pull up Exhibit 12? Thank you. Ms. Cusack, were you able to watch Exhibit 12 or do you need it to be played again for you?
I was able to view it, thank you.
Okay, perfect. What is Exhibit 12?
Exhibit 12 is the video of the perpetrator unlawfully entering Mackenzie Brackman's home.
How do you know this?
It is the video that I reviewed in my investigation.
Is it a fair and accurate representation of the video that you reviewed in your investigation?
It is, yes.
Your Honor, I now move to enter Exhibit 12 into evidence.
Any objection?
No objection, Your Honor.
It'll be admitted.
Ms. Bennett Spurlock, may you please play Exhibit 12 so the jury members may view it? Ms. Cusack, what conclusion did this video lead you to about the perpetrator?
Well, this video is critical because not only does it show the general height and build of the intruder, which matches the exact general height and build of the defendant, Avery Becker, but it also establishes that the intruder was wearing gloves, which is why no DNA evidence other than Mackenzie Brackman's was retrieved from the scene.
Thank you, Ms. Bennett Spurlock. You may stop screen sharing now. Ms. Cusack, you stated that along with videos, you also analyzed photographs. What did these photographs show you?
Yes, I also analyzed photographs of floor scuffing, an open drawer with several small knives in it, a knife block on the kitchen counter with an open knife slot in it for a large chef's knife, just like the one we retrieved from the body, and a broken plate.
Did the photographs provide any other insight into your investigation?
Yes, the floor scuffing photographs indicated that there was a struggle between 2 individuals.
Ms. Cusack, did you review the autopsy report in this case?
I did, yes.
What did it tell you?
The autopsy establishes that the victim was stabbed only 1 time in the upper back shoulder area.
So you mentioned that making timelines are an incredibly important part of your process. Did you develop a timeline of the day of March 6th in order for you to come to your conclusion about this case?
I did, yes.
Would you be able to go over this timeline for us, please?
Yes, so first, the victim must have been alerted about the intruder's presence from the ring security system. He then likely looked for a defense weapon in the knife drawer, but then proceeded to the knife block for the larger chef's knife to introduce him to the encounter.
And then based on this timeline, what did you conclude happened when the victim confronted the intruder?
The 2 likely struggled over the knife in the kitchen, causing the plate to crash to the floor. And in the ensuing struggle, the intruder disarmed the victim and obtained the chef's knife.
And then what happened when the intruder grabbed the chef's knife?
Well, the intruder must have reached over the victim from a bear hug position and stabbed the intruder in the upper back shoulder area as indicated from the stab wound.
Ms. Cusack, were you aware that there were other experts working this case?
Yes, I'm aware that Blake Van Owen is working this case for the defense.
Did you review Mr. Van Owen's theories?
I did, yes.
And do you agree with his theories?
No.
Why not?
Well, Blake Van Owen regrets to include critical evidence and information in this case. He regrets to include the floor scuffing, the open knife drawer, the block with the empty knife slot in it, the broken plate, and on top of that, Blake Van Owen also suggests that Brackman was surprised, which is a ridiculous theory.
Why is that ridiculous?
Well, not only did Brackman own Ring security systems, which sole purpose is to notify homeowners of movement near the house, but he was also paying an extra monthly subscription to keep access to these recorded videos. And he would have also been notified by the intruder's entrance through the door and shuffling through the kitchen.
Was your investigation thorough in this case?
Yes.
Do you feel you had sufficient evidence to come to a conclusion?
Yes, I do.
Ms. Cusack, in your expert opinion and your meticulously conducted reconstruction, what is your conclusion of this case?
In the end, this was clearly a planned burglary gone bad. The intruder had knowledge of the victim's residence and likely chose a time of day that would have placed the victim outside of the home. However, unfortunately, the victim was present and alerted to the intruder's presence before the intruder entered the home. And so he armed himself, but unfortunately, in the ensuing struggle, he was killed with the same knife that he introduced in the encounter in the first place.
Thank you, Ms. Cusack. No further questions at your time, Your Honor. Your Honor.
Thank you, counsel. Cross-examination.
Yes, Your Honor. May I proceed?
Yes, please do.
Ms. Cusack, you believe that Mr. Brackman was sitting at his table when he received a notification on his phone of the intruder, right?
No, I do not. I did not indicate a location where Brackman was when he received these notifications. I do, however, believe that Brackman did receive the Ring doorbell notifications.
But Ms. Cusack, no investigation was done by either you or anybody on the prosecution to see whether he actually received that notification, right?
Considering that Mr. Brackman owned Ring security systems, which sole purpose is to notify him of that movement,
I'm sorry,
and
Ms.
he was
Cusack.
also paying the
Excuse
extra
me, Ms.
fee
Cusack.
to get these videos.
Objection, Your Honor.
Yes, we concluded.
Unresponsive.
The court will instruct the witness to respond to the question. Your counsel will have the opportunity to expand on your answers if they choose it's inappropriate.
I'll ask my question again, Ms. Cusack. No investigation was done by either you or anybody on the prosecution to see whether he received those notifications, yes or no?
None was needed, no.
But it is your opinion that Mr. Brackman received these notifications and thought somebody was trying to break in.
Yes.
So first he runs to the kitchen, he opens up a drawer with knives and chooses not to take any of those knives, correct?
Correct.
Instead, he moves around and he grabs another knife from a chef block, correct?
He grabbed the large chef knife from the chef block, yes, instead of the small knives.
And Ms. Cusack, instead of calling the police, he chose to arm himself, in your opinion, yes or no?
Your Honor. Oh.
You can answer.
Oh, no. Can you repeat the question? Sorry.
Ms. Cusack, instead of calling the police, Mr. Brackman chose to arm himself, yes or no?
Objection, Your Honor.
Yes, he did.
I'm sorry, is there an objection?
Yes, Your Honor. Speculation. This opposing counsel is asking my witness to testify to Mr. Brackman's thoughts in the moment as to whether he should call 911 or grab the knife. And Ms. Cusack is not aware of Mr. Brackman's mindset during that time. She solely based her investigation off the evidence. She has no idea of knowing Mr. Brackman's mindset at that time.
Response?
Your Honor, given that opposing counsel and Ms. Cusack opened the door to Mr. Brackman's movements within the home prior to the intruder entering, the door has been opened to question that linear timeline of events. Furthermore, I am not asking Ms. Cusack to speculate. I'm simply asking for her to confirm the facts that Mr. Brackman did not call 911 and instead, in her opinion, ran to the kitchen.
Any brief reply?
Your Honor, I do believe the question asked that Mr. Brackman chose to grab the knife instead of calling 911. My witness cannot testify to the choices that Mr. Brackman made that were going through his head at the time.
The court will allow the question. It doesn't see this as getting to the state of mind of the witness, but rather the actions that the witness took. And this is a crime scene reconstruction opinion. The answer will stand, and counsel, you may proceed.
So, Ms. Cusack, Mr. Brackman chose not to call 911, yes?
Not when there was an unknown intruder entering his house, no.
And as the intruder moved around to the back of the house, isn't it true that Mr. Brackman didn't run out the front door?
No.
And so now you believe that when Mr. Brackman has this knife, the intruder has made their way to the back side of the house, correct?
Yes.
And it's your opinion that the intruder and the victim never saw each other through that glass door we saw in Exhibit 12, correct?
I don't know if they saw each other through the glass door. All I know is that Brackman was aware that there was an intruder due to the ring security system.
And once inside, you believe that the intruder and Mr. Brackman had an altercation, I believe you said a scuffle, just inside that back door, correct?
Yes, I do.
Please turn your attention to Exhibit 18. Do you recognize this image?
Yes, this is the image of the floor scuff marks.
Is it a fair and accurate representation of what you saw at the crime scene?
It is, yes.
Your Honor, I move to enter Exhibit 18.
Any objection?
No, Your Honor.
It's admitted.
Ms. Cusack, isn't it true that you believe these scuff marks were created by two separate people?
No, I do not believe that. I believe that the scuff marks indicate a struggle between two people, not that they were created by two people.
Ms. Cusack, you made a statement in this case?
I did.
And in that statement, you swore to include everything, you swore to tell the truth, correct?
Yes.
And please turn your attention to the statement in front of you. It should be just in front of you physically.
Yes.
If you look at the last page of your statement, that's your signature, isn't it?
It is.
And in that statement, you say that this scuffle was created by two separate people, don't you?
I do not. In my statement, I say that the floor scuff marks indicate a struggle between two individuals, not that they were created by two individuals.
And Ms. Cusack, you also permission to screen share Exhibit 12, Your Honor.
You may do so.
Ms. Cusack, looking at the end of this video, we never see Mr. Brackman in this exhibit, do we?
No, we do not. Mr. Brackman was inside his house.
And once the intruder is inside Mr. Brackman's house, we still don't see Mr. Brackman, do we?
No, all we see is the outside of the home. We do not see anything inside the home.
Now you believe that once inside and once your scuffle occurs, the intruder stabbed Mr. Brackman in the back, correct?
I do, yes.
And once the intruder fled the scene, you believe that Mr. Brackman reached over and pulled the knife out of his own back, correct?
Yes, Mr. Brackman pulled the all-metal 12-inch knife out of his own back.
And Ms. Cusack, you know this timeline and where he was stabbed, partially because of blood spatter images, correct?
Yes.
And you inserted these images into your own spreadsheets, right?
I did. I used these images to develop my conclusion.
And isn't it true that Detective Markowitz lost these images?
Unfortunately, these images were lost. However, I was able to review them prior to them being lost and incorporate all of this evidence.
Excuse me, Ms. Cusack. My question was not whether you could review them. My question was whether they were lost by Detective Markowitz. They were lost by Detective Markowitz, weren't they?
They were lost.
And Ms. Cusack, isn't it true that you too lost these photos because they were inserted into your own spreadsheets? Yes or no?
They were lost on my team, but what I inserted into my spreadsheets was the knowledge that I had from the exhibits, which I was able to view before they were lost.
Now, Ms. Cusack, you mentioned some witness tracking spreadsheets, right?
I did not mention it, but I do have a witness tracking sheet.
And in that sheet that you created, you identify 3 suspects, correct?
Yes.
Objection, Your Honor.
Please explain.
Facts not in evidence. Opposing counsel is asking my witness to testify to the contents of the witness tracking sheet, which has not been entered into evidence at this time.
Response, counsel?
Your Honor, pursuant to Rule 703, experts can base their opinions off of previously not admitted evidence or evidence that would be otherwise inadmissible.
Any reply?
No, Your Honor.
The court will allow it. This is cross-examination, and the basis of the experts' full opinions are all in play. Counsel, you may proceed.
Ms. Cusack, isn't it true that you identified 3 suspects in your witness tracking spreadsheet?
Yes.
And isn't it true that you only investigated 1 suspect, Ms. Avery Becker?
That's not in my statement. Would you like me to answer?
I'm sorry, Ms. Cusack, I don't think you understand my question. My question was, you only mentioned Ms. Becker in your witness statement, don't you?
Yes, because this is the trial of Avery Becker. So my statement is about Avery Becker.
And Ms. Cusack, it's to your knowledge that the detective, Jordan Markowitz, never got an interview with the defendant, Ms. Becker, right?
Yes.
And isn't it true that in your spreadsheet, you yourself had an interview with the defendant, Ms. Becker?
That's not true.
Sorry, was there an objection?
Yes, there was. I'm objecting to facts, not in evidence. The witness may testify to her opinion that was developed based on this witness tracking sheet. However, she cannot testify to the contents of the witness tracking sheet because it has not been entered into evidence. However, if opposing counsel would like my witness to testify to her opinion that she developed based on the witness tracking sheet, that is okay, but I ask that the contents not be discussed unless it's entered into evidence.
Response.
Your Honor, Rule 703 was created so that experts may form an opinion based on inadmissible evidence or something that's not entered into evidence. Likewise, to refute an opinion that was created, one can use Rule 703 and admit inadmissible evidence for an expert to testify on.
Any reply?
Yes, Your Honor. Rule 703 says that an expert witness may base an opinion based on facts or data. However, he's not asking my witness to create an opinion based on this. He's asking her to testify to the direct contents of the witness tracking sheet, which has not been entered into evidence.
Counsel, can you lay some foundation that in fact the witness relied upon or used this spreadsheet as part of her opinion development?
Yes, Judge. Ms. Cusack, you mentioned on direct examination that you used a 5-step process, right?
Yes.
And in steps 2 and steps 3 and throughout your entire process, actually, you developed a witness tracking spreadsheet to help you better understand the evidence that you found. Isn't that right?
I actually developed my witness tracking sheet in step 2, and I use that through the other steps, but yes.
And isn't it true that you investigated Ms. Becker, the defendant, in July?
That's not in my statement. Would you like me to answer?
Yes.
No, I did not. I do not conduct investigations.
Your Honor, permission to screen share Exhibit 17 for purposes of impeachment.
Any response?
May I ask opposing counsel to clarify what Exhibit 17 is?
Your Honor, Exhibit 17 is that witness tracking spreadsheet that I will have the witness, Ms. Cusack, testify to.
Yes, right. Sorry, my apologies.
Yeah, permission to impeach with the document is allowed.
Your Honor, pursuant to Rule 6.3, if on cross-examination a witness is asked a question which calls for information that is not in the witness's statement, the witness may indicate that that information is not in the witness's statement, but offer to provide an answer. She said it wasn't in her statement, so she provided an answer. Exhibit 17 has not been entered into evidence, so she wasn't able to testify to the facts of Exhibit 17. So in that answer, she wasn't able to testify to what had been previously stated in Exhibit 17 due to the fact that it hasn't been entered into evidence.
Your Honor, if I may?
Please.
Your Honor, given that Ms. Cusack admitted that she created this document and she referenced said document in her witness statement, it directly links her to this document. And further, pursuant to Rule 613B, extrinsic evidence of a prior inconsistent statement is allowed for purposes of impeachment, which is what I'm doing here.
Any reply?
Your Honor, I still don't believe that Exhibit 17 has been entered into evidence. So I would ask that because opposing counsel was asking my witness to testify something that was contained in Exhibit 17, he cannot impeach her by that because my witness cannot testify to that due to the fact that Exhibit 17 has not been entered into evidence at this point.
Your Honor, if I may?
I don't think you need to, counsel. this is proper impeachment of an expert witness using materials from the expert's files. While the document will not be admitted into evidence, and the jury should not be swayed by the contents, it's allowed as to impeachment of the witness with respect to the opinions. Counsel, you may proceed.
So, Ms. Cusack, in the second column down, if you'll follow with me, doesn't it say interview report of Avery Becker, the defendant?
Yes, I believe you misunderstand my witness tracking sheet. This is a reference of the interview report, not a direct interview with Avery Becker. So this is a collection of all
Ms.
the
Cusack,
interviews.
that wasn't my question. Did I read that correctly first? Yes or no?
Yes, interview report, the document.
So, Ms. Cusack, you had access to an interview that somebody had with the defendant, yes or no?
That's incorrect, no.
You didn't have access to an interview, but you included it in your witness tracking spreadsheet, didn't you?
I had access to the document labeled interview report. However, this is not a specific interview with the defendant, Avery Becker, no.
It's not a specific interview with the defendant, even though it says expressed remorse about a prior involvement with the victim on the CHS team?
No, because we could have found this out from Taylor, from Alex. We can find out that the defendant expressed remorse from any of the interviews that were placed.
Your Honor, I have no further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor. Ms. Cusack, were you? Thank you. Ms. Cusack, were you able to identify if Mr. Brackman was sitting at the table at the time that he was stabbed?
No.
And can you go over for us again your analysis of the scuff marks?
Yes, the scuff marks indicated that there was a struggle between two individuals, not that they were created by two individuals. So the scuff marks could have come from the intruder's shoes or from a chair.
Did you conduct an interview of the defendant, Ms. Avery Becker?
No, I did not.
Thank you. No further questions, Your Honor.
Any recross?
No, Your Honor.
Thank you, counsel. The witness may step down. Prosecution, I believe you have one remaining witness. Would you like to call that person?
Yes, Your Honor. The prosecution calls Detective Markowitz.
Detective Markowitz, you understand that you are still under oath. Counsel,
Yes.
You may proceed.
Good morning, Ms. Markowitz. Could you please state your name and spell your last for the record?
Jordan Markowitz, Markowitz.
Ms. Markowitz, what do you currently do for a living?
I'm a homicide detective at the Denver Police Department.
And how long would you say you have been working in law enforcement?
I've worked at the PD for 13 years and I've been a detective for 7 years.
And do you have any specialized training as a detective?
Yes, I have my certification in cell phone technology and forensic data recovery from the American Academy for Law Enforcement.
And how often do you use this training in your work, detective?
I use my knowledge of cell phone technology and forensic data recovery all the time. I've downloaded the contents of hundreds of phones. As to cell phone or cell tower data, as it pertains to this case, I've used that in over 50 similar cases.
Your Honor, at this time, I move to enter Detective Markowitz as an expert in homicide investigation as well as cell phone data recovery and analysis pursuant to Rule 702.
Any objection, counsel?
No, Your Honor.
The court will accept the witness's testimony as expert in the fields of homicide investigation and cell phone data recovery. Counsel, you may proceed.
Thank you, Your Honor. Detective, how did you become involved in this case?
On March 6th of 2020, I was called to investigate the death of Mackenzie Brackman.
And did you visit the crime scene?
Yes, I was able to visit Brackman's residence pretty much immediately after the 911 call was dispatched.
Detective, what did you observe upon arriving at the scene?
When I first arrived at Brackman's residence, I observed that the front door was open and I observed Mr. Brackman face down just inside his home, just inside the front door. Next to the body, there was a large chef's knife, which clearly had been the murder weapon.
And what did you do after making these initial observations?
I actually didn't enter the house through the front door. I ended up walking around the home and I observed 3 Ring doorbells on my way. And then I entered what I believe was the dining room. I entered through the back door.
And what was the state of the home when you entered?
The dining room was in disarray. There was a knocked over chair and a broken plate on the floor, which led me to conclude that there had been some sort of scuffle or struggle in the dining room.
What did you observe in the kitchen?
When I walked into the kitchen, which is a little further into the home, I observed an open drawer with like a ton of knives in it and a knife block sitting on the counter with a large chef's knife, a slot for a large chef's knife missing.
So what conclusions did you draw from these observations, Detective?
Evidence of a struggle in the dining room and the knives in the kitchen led me to believe that Mr. Brackman was alerted to the intruder, grabbed a knife to arm himself, and then a struggle ensued. The intruder got the knife from Brackman and ended up fatally stabbing Brackman.
So in your expert opinion, did the intruder enter the residence with a knife?
It simply doesn't make logical sense for the intruder to have brought their own knife, seeing that a struggle ensued and also, like I said, that the knife drawer was open, the knife block had a missing slot.
So, Detective, what did you do next in your investigation?
I did what any good detective does, and that is turning to the evidence to determine who had murdered Mackenzie Brackman.
And what did that entail?
My first step was to download the contents of Brackman's phone. And by downloading his phone, I learned that Brackman was both a criminal defense lawyer, which I already knew, and also that he was really invested in something called mock trial. He had like a ton of texts about it. So I actually ended up receiving the contact information for the kids in the mock trial team, just because I thought they might know something.
Okay, and did you end up contacting any of these students?
Yes, I did. I started going down the list, and Alex Cifuentes I ended up calling, and Alex gave me some crucial information into this case.
Can you tell us about that phone call, Detective?
Yes. Alex Cifuentes informed me over the phone that Avery Becker had texted her with a plan to break into and trash Mr. Brackman's home while he was away at work. This was presumably to get revenge for being kicked off the mock trial team.
Objection, Your Honor, speculation.
Any response, counsel?
Your Honor, I can lay a little bit more foundation as to how Detective Markowitz knew this.
Any reply?
No matter what foundation is laid, she cannot speculate to Ms. Becker's plan in this case and what she was thinking at these times and why she sent these messages.
Yeah, the court agrees. The jury will disregard the statement about the state of mind, but as to the actual facts that the expert has investigated and reconstructed, that's permissible. Counsel, you may proceed.
Thank you, Your Honor. Detective, what did you do after you learned about this plan to trash the house?
Since I knew that Becker had a plan to trash the house, I called Alex Cifuentes in to the PD headquarters for an interview to learn more.
Objection, Your Honor. She again stated that Ms. Becker had a plan to trash the house. That is again going to mindset.
Any response?
Yes, Your Honor. First of all, the texts that Exhibit 14 that state this plan that Detective Markowitz reviewed in her investigation have already been entered into evidence. So this plan is already part of evidence.
May I briefly respond, Your Honor?
Yes.
In accordance with Rule 704B, an expert witness cannot testify in a homicide case to the ultimate issue or the mindset of the defendant. In this case, she is testifying to her mindset as planned. And so that is inadmissible evidence and is going to the ultimate issue of this case.
The court will allow the testimony because this is an expert and the document does provide sufficient foundation for those opinions in the sequence. However, the witness is advised that speculation as to the state of mind of the witness is not really something that an opinion can be given about. So with that understanding, counsel, you may proceed.
Thank you, Your Honor. Detective, let's go back to these texts from Alex Cifuentes. Can you tell us what happened when you interviewed her?
Yes. So as I said, Alex Cifuentes came in with her parents into the headquarters for an interview. Alex had actually forgotten her phone, something about like faulty battery. And what ended up happening is I asked her after the interview for screenshots of this conversation, which I of course now have reviewed.
Okay, and what did you do after this interview with Miss Cifuentes?
I knew that it was going to be important to reach out to Avery Becker, so I did, but Avery Becker lawyered up, and so I was not able to get an interview with her. I also got a warrant to search Avery's phone, but Avery's lawyer informed me that Avery had conveniently lost her phone the day before. So therefore,
Your Honor, I object. Earlier in the statement, she is making the insinuation that Avery Becker did not come in for an interview because she had something to hide. And it is her Fifth Amendment right to deny an interview in this case, and therefore has that right. And to testify that she didn't come into an interview is going against that right that she has.
Any response?
Your Honor, could I ask the opposing counsel to clarify the statement that Detective Markowitz made that she's objecting to?
Counsel, specifically, what testimony do you have an issue with?
Yes, Your Honor. When she stated that I contacted Avery Becker for an interview and she denied it and lawyered up that statement around those terms.
Any response to that, counsel?
Your Honor, Detective Markowitz gave the reason why Avery and her attorney declined to allow this interview to take place.
All right. The court will sustain the objection and the jury will disregard the testimony beyond the fact that this witness was not able to interview Ms. Becker or to inspect the cell phone. You may proceed, counsel.
Thank you, Your Honor. Detective, what data were you able to collect about Ms. Becker's phone?
so since I couldn't obtain the cell phone, I ended up getting a warrant to obtain the cell tower data records for March 6th as they pertain to Avery Becker's phone.
And Detective, could you tell us a little bit about how cell tower data helps an investigation?
Absolutely. So cell tower data essentially works like this. Whenever you make or receive a call or text, it's going to ping off of what is usually the nearest cell tower. What I do is I go to service providers and I ask them for the locations of these cell towers. By knowing the cell towers locations, I can create a general picture of the phone's location throughout the day.
Your Honor, permission for my timekeeper to go ahead and share Exhibit 16 for the witness to view.
Permission granted.
Detective, could you identify, or excuse me, I said 16. This is 15 and that's what I meant. My apologies. Detective, could you go ahead and identify Exhibit 15?
Absolutely. This is a diagram I created. It's very common for police to create diagrams like this, and it shows the cell tower data records from March 6th.
And how do you know this?
I made it myself.
And is it a fair and accurate representation of the diagram you created?
Yep.
Your Honor, at this time, we move to enter Exhibit 15 into evidence.
Any objection?
Yes, Your Honor. I object to hearsay and foundation.
Response?
Yes, Your Honor, to the hearsay. But first, could opposing counsel clarify what more foundation they think needs to be laid?
Can you explain the objection?
Yes, Your Honor. To the foundation objection, it has not been identified that Detective Markowitz knows this area, is familiar with the cell towers in this area, and because that foundation has not been laid, we do not know whether or not she can testify on this exhibit. As to the hearsay objection, there are black pins throughout this exhibit that are out-of-court statements being used for the truth of the matter asserted to show the location, and Detective Markowitz testified that she put these pins in place because she created this map, and therefore they are hearsay.
Any reply?
Yes, Your Honor. As to the lack of foundation objection, the witness testified as to how she obtained these cell tower records, which was from the cell provider, which, gave her the map of this area. So that is how she became familiar with the area. So I do believe enough foundation has been laid. As to the hearsay objection, I believe I understand the opposing counsel's objection, and I would say that these pins that the opposing counsel is referring to, first of all, mark locations that are not disputed. It's not disputed where these locations are. And also under Rule 803-6, this is a record of a regularly conducted police activity. So I do believe that it's admissible.
Any reply?
Yes, Your Honor, the foundation has not been laid that this is a regularly conducted practice, and therefore that hearsay exception is not relevant to this case until that foundation has been laid. And it also is not stipulated as one of the 4 stipulated facts that were read into the record earlier that these locations are not disputed.
Thank you, counsel. The court will allow the exhibit as to hearsay. This is simply a diagram that's been offered by an expert who prepared it in the course of development of that witness's opinions. As to foundation, I find that sufficient foundation has been laid for developing the information that's reflected on the exhibit. Counsel, you may proceed.
Thank you, Your Honor. Detective, could you tell us just a little bit about this exhibit?
Absolutely. So on this exhibit, there are 3 antennas, cell tower antennas, and those are going to show us the area that these cell towers cover. Next to these are going to be the times that Avery Becker's phone communicated with these towers. And of course, here is Becker's home, and here is Brackman's home. At 12:47, the phone was clearly in the range of Becker's home. At 12:55, it was traveling down this path, and at times leading up to 1:17, the phone was pinging off this tower, which clearly places Becker in the same cell tower range as Brackman's home.
And did Becker's phone receive any other communications on the day of the murder?
No, at 13:20 hours, it was shut off and disposed of after the murder.
So what conclusions were you able to make based off of this cell tower data?
The cell tower data clearly shows that Becker was at Brackman's home at the time of the murder.
So, Detective, how was Mackenzie Brackman murdered in your expert opinion?
It's clear that Avery traveled to the home, got a hold of the knife in a struggle, and stabbed Mr. Brackman.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor.
You may proceed.
Detective Markowitz, you took photos of the crime scene, correct?
No, I didn't.
You analyzed photos of the crime scene, didn't you?
Yes, my team took them.
And please turn your attention to exhibits 1 and 4. These are photos of the crime scene, correct?
Yes, those are photos of Mr. Brackman.
Are these fair and accurate depictions of the photos you reviewed?
Yes.
None of the defense offers exhibits 1 and 4.
Any objection?
No, Your Honor.
They'll be admitted. You may proceed.
Detective Markowitz, in exhibit 1, Mr. Brackman's hand is above his head, correct?
Yes.
And in exhibit 4, his hand is to the right of his head.
Yes.
Someone moved the body.
Objection,
It would
Your Honor.
appear.
There was an objection, I think.
Yes, Your Honor. Relevance.
Counsel, response?
Your Honor, under Rule 401A, a relevant fact makes the fact more or less probable in this case. This piece of evidence and showing that the body was moved throughout the course of this trial is going to show that Detective Markowitz's investigation was flawed and goes to the credibility of it because the body has been moved through the investigation, and that shows some discrepancies within her investigation, and credibility is always relevant.
Any reply?
Yes, Your Honor. I do not believe that this is relevant to show anything in this investigation because how Mr. Brackman was killed, where he was killed, why he was killed is not at dispute. This isn't relevant.
The court will allow the testimony. Cross-examination is broad by nature, and I'm sure counsel will make the significance of this information known at some point. You may proceed.
Someone moved the body.
It would appear that way. That's not that uncommon.
And you also took photos of blood splatter at the crime scene.
I once again didn't take the photos.
Your team took photos?
Yes.
And those were corrupted, weren't they?
Yes.
And the defense never had a chance to review them.
Well, I mean, I saw the blood spatter, so it doesn't really matter.
But the defense didn't have a chance to review them.
Detective Kuzak did review them.
The defense.
I don't believe they have, no.
And you said Alex Cifuentes gave you a break at the police station, didn't you?
Alex Cifuentes told me about the text from Avery Becker of a plan to trash Mr. Brackman's home.
But he only sent you screenshots. He didn't show you the actual phone.
Yeah, as she said, her phone was being weird.
And without those actual phone, you couldn't tell if those texts had been doctored or not.
I looked at the text and there was no evidence of doctoring.
But you didn't actually see the phone, did you?
No, because the battery wasn't working.
You also analyzed call detail records.
Yes, I did.
But that shows where a phone is, not who has the phone.
Well, it's safe to assume that Avery had Avery's phone,
But
not aliens.
Avery lost her phone on March 5th, the day before you took these cell tower records.
Isn't that convenient that she lost it the day before the murder?
So it's fair to assume she actually didn't have her phone, so these call detail records don't matter.
That is not fair to assume at all.
She didn't have her phone on March 6th.
I can't say whether she did or did not.
Because you didn't get the call detail records from March 5th to confirm her story, did you?
No, I did not.
Now, you also, please turn your attention to Exhibit 15. To the left of Miss Becker's home says Blair Rollins' house, doesn't it?
Yes, that was part of my investigation of Blair Rollins.
But actually, nowhere in your statement do you say you investigated Blair Rollins.
My statement was for the trial of Avery Becker, so no, I did not mention Blair Rollins.
And you're aware that and if Blair Rollins had Miss Becker's phone, he would have created a similar pattern with the call detail records, wouldn't he have?
I cannot say whether or not Blair Rollins had Avery's phone, but I assume that Avery had Avery's phone.
But if he did have her phone, he would make a similar pattern, wouldn't he?
Sure.
Now you're aware that Mr. Brackman was a criminal defense attorney.
Yes.
And that the perpetrator could have been a disgruntled ex-client.
That is a possibility, but these facts point to Avery Becker.
But you never investigated Blair Rollins' father, whose criminal defense attorney was Mr. Brackman.
That's not in my statement, but I'd love to answer that for you.
Exactly. Never in your statement did you include you investigated Blair Rollins' father.
Not in my statement regarding Avery Becker, but I can tell you all about my investigation of Blair Rollins' father if you would like.
And you're aware of a court proceeding involving Blair Rollins' father and a statement made by that, aren't you?
No, I am not.
Your Honor, permission to enter Exhibit 22, which has been stipulated as authentic by both parties in this case to play for Detective Markowitz.
Any response or objection?
Yes, Your Honor. To lack of foundation and lack of personal knowledge, you just heard the witness say that she has no knowledge of this exhibit, and therefore the opposing counsel cannot lay the proper foundation necessary to enter it. Also, I'd just like to point out that this clip is 4 seconds long. Thus, we have no ability to know the context surrounding the contents of the statement. My witness can't testify to this exhibit. It can't be entered.
Any reply?
Yes, Your Honor. Detective Markowitz has been entered as an expert witness in the field of homicide investigation. He is an investigator in this case, and it is her duty to investigate every possible suspect. So by playing this audio, I'm going to show that she did not investigate every possible suspect and failed to investigate Blair Rollins, whose father is speaking in this case. It is not necessary for her to have personal knowledge of this audio tape because she is an expert witness. I'm going to get her opinion on this audio tape as she has already been entered as an expert witness in this field. And as I assume will happen, Professor Van Owen will speak to the contents and the information surrounding this audio tape later in the trial to provide more foundation. I'm merely getting Detective Markowitz's opinion on this matter.
All right, subject to it being linked up later in the defense case, this is proper impeachment of the witness's opinion development. You may proceed.
I'll get you back, Brackman, if it's the last thing I do.
Someone threatened Mr. Brackman in this audio recording.
Yep, just like Avery Becker said she'd get back at Mr. Brackman to her mother.
Markowitz, I didn't ask you. Someone threatened Mr. Brackman in this audio recording, yes or no?
Someone who's in jail for life.
Exactly. And his son also goes to CHS, doesn't he?
Blair Rollins, who I investigated because it's on Exhibit 15.
Nowhere in your statement do you say you investigated Blair Rollins, do you?
Once again, my statement pertains to Avery.
So you never investigated the person in this audio recording? Nowhere in your statement?
That's not in my statement.
Nowhere in your statement do you say you investigated this person, yes or no?
No, I don't.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Or actually, no, Your Honor. I don't think it's necessary. Thank you.
All right. The witness may stand down, and I apologize, but I believe that's the last witness for the prosecution. Is that accurate?
Yes, Your Honor.
Does the prosecution rest?
Yes, Your Honor.
And I apologize. The court needs to take a 2-minute recess, and we can reconvene with the defense case at that point. Thank you, everyone. We can reconvene. And do I still have all of my scoring panelists?
Yep, I'm here.
Thanks, Nate. Heidi and Elizabeth?
I am.
Thank you, Heidi.
Yeah.
Elizabeth?
Elizabeth Jones, are you present?
Oh, yes, I am. Sorry.
Thank you. I appreciate it. The defense may call its first witness.
The defense calls Avery Becker.
Ms. Becker, I'll remind you that you are under oath.
Yes, Your Honor.
Counsel, you may proceed.
Ms. Becker, why are you here?
I'm here because they are trying to convince you that I was the one that murdered my mock trial coach. And I promise that that's not true at all. I would never do anything like that to Mr. Brackman.
There's been a lot of testimony today about your relationship with Mr. Brackman. Can you explain how that relationship actually was?
Sure. Coach and I didn't always get along 100% of the time, but in the end, we needed each other, whether we liked it or not.
Was there respect within your relationship?
Yes, of course there was. Coach always gave me the experts, and they were pretty good roles.
And what roles did he give you in the 2020 season?
Our season last year was fairly simple. It was about these old people arguing over who got their mother's will, and I was the one that directed the mother's nurse, and I crossed her doctor.
Were these the best roles?
Yeah, I would say that they were pretty good roles.
Was there respect within your relationship?
Yes, of course there was.
Now let's talk about regionals. What happened prior to the regionals tournament last year?
Right before the regional tournament, Coach and I got in a little disagreement. It was really just about my work ethic, and apparently it seemed to bother Coach because he demoted me to the B team right before regionals.
What happened after that?
Well, Taylor Perkins. She's my best friend. She just didn't like mock trial that much, and so she stepped down and I was able to get back on.
How'd your team do at regionals?
We won, and it was such a wonderful day, and it was so incredible.
How'd you do?
I did pretty well. I got the best attorney award and the best closing award, and I was just so proud of myself.
And after this, how was your relationship with Mr. Brackman?
Our relationship got worse. Coach seemed so angry that I had won any awards at all at the tournament, and in front of my whole mock trial team, he told me that I didn't deserve those awards, and the only reason I ever deserved those awards was because I looked good.
How did you respond to that?
I was humiliated, and I was upset, and I just didn't want to be insulted anymore, so I walked out of the classroom.
What happened after that?
I had a dry erase marker in my hand, and I was about to write on the whiteboard before Coach started insulting me. I never should have done this. This was one of the worst choices that I've ever made in my life, but I went and I wrote on his Porsche, and I never should have done that.
What did you believe was in your hand?
I swear, I thought it was a dry erase marker, and it later turns out it was a permanent marker, and I never would have done that if I had known that before.
Did you apologize?
Yes, of course I did. The next day I tried to go to his office, but he wouldn't see me, and then I tried to text him, but he never responded, and now I'll never be able to say I'm sorry to him because someone murdered my coach.
Now let's move to March 5th. What were you doing that day?
Well, Taylor and I, we went to the Fry Shack and the mall since I couldn't go to mock trial anymore.
Did you see anyone you knew there?
Yeah, I saw a lot of my old teammates there, including Alex Cifuentes.
Did you hear Alex Cifuentes' testimony today?
Yes, I did.
And do you agree with her characterization of your friendship?
Absolutely not. I don't know why she is testifying that we're friends, because we are not friends at all.
And did you hear her testimony about alleged text messages?
Yes, I did. And I think it is absolutely absurd because I did not send those text messages at all. I don't know where she got those text messages from. She must have made them up because I did not send those text messages at all.
Now, did you have your phone with you the whole time on March 5th?
No, I actually didn't. For some reason, Alex wanted to play games on my phone, so I just gave it to her, and I haven't seen my phone since.
When did you realize it was missing?
Well, I woke up the next day and I just couldn't find it anywhere.
When was the last time you remember seeing it?
The last time I remember seeing it was when I gave it to Alex at the Fry Shack.
After realizing it was missing, what did you do?
Well, Taylor and I went and skipped school the next day to look for it. It really wasn't that big of a deal because we were with each other the whole day.
Where did you go to look for it?
Well, we went to the Fry Shack and the mall, and we basically retraced our steps looking for it. And we were calling it, we were texting it, and we even checked with the afternoon shift staff, but at the Fry Shack, we never found it.
Now let's talk about the mock trial team. Who would benefit the most if you were not on the team?
Objection. Speculation.
Okay. Any response?
Yes, Your Honor. This statement coming from Ms. Becker, she's been on the mock trial team for the past 4 years. She has gotten these roles. She's been kicked off the team, so she knows who would receive those roles if she weren't on the team, and therefore would not be speculating onto who would benefit the most and who would get those roles.
Any reply?
Your Honor, I understand what opposing counsel is pointing out about Avery having been on the team, but this doesn't mean that she had any knowledge about what would happen when she wasn't there. That is the definition of speculation. It's a guess.
The court will allow the question with the understanding that the witness will be providing her perspective based on the facts as she knows them. Counsel, you may proceed.
In your opinion, who would benefit the most if you were not on the team?
Based on what I saw when I was at mock trial practice, I think that Alex Fuentes definitely would have gotten my roles.
Do you know who Blair Rollins is?
Yeah, I know of him. He was one of my classmates at CHS.
And did he have a reputation in the community?
Definitely. He had a massive reputation in the whole CHS community for absolutely hating Coach Brackman.
Objection.
Basis?
Lack of foundation as to how the witness knew about this reputation.
Any response?
Yes, Your Honor, the foundation has been laid that Ms. Becker went to CHS for 4 years. She was part of this community, pretty large a part of this community for being on mock trial team for 4 years and being involved. She went to school there. She would know the reputation that Blair Rollins had within this community. So the foundation has been laid.
Any reply?
Yes, Your Honor. At this point, I guess I'd like to change my objection to hearsay. As opposing counsel stated, that this was a reputation in the community, implying that Miss Becker must have heard it from someone, and this statement or this fact or opinion about Blair is being offered for the truth of the matter asserted.
Any response to the hearsay objection?
Your Honor, what exact statement is opposing counsel objecting to for this case?
I guess you need to explain the objection a little bit further.
Yes, Ms. Becker stated that Blair Rollins hated Mr. Brackman.
May I respond?
She must have heard this.
Sorry for interrupting.
In response, I think you were done, counsel. Yes.
Yes.
Okay,
Sorry,
thank you.
I misheard the objection, but now I understand. In accordance with Rule 803.21, reputation concerning character is admissible, and it's an exception to the hearsay rule, and so therefore this is admissible.
The court will allow it to the extent that it is being offered as reputation. The witness should be careful not to speak as to the state of mind or the understanding of some other person within the high school, but with the understanding that the testimony is going to address reputation, the court will allow it.
What was Blair Rollins' reputation in the community?
Well, Blair Rollins had a huge reputation in the CHS community for absolutely hating Coach Brackman.
Why was that?
Well, it was mainly because Coach Brackman represented Blair's father in a criminal defense trial.
Objection.
Basis?
Lack of foundation. I don't know. Information has been given as to how the witness knew this.
Any response?
Your Honor, it has been gone over that Avery Becker was in this community. She knew the reputation and is still testifying to the reputation of the community. And this is the reputation of why everyone thought that he hated Mr. Brackman, and going towards that reputation that the foundation has been laid for.
Any brief reply?
Opposing counsel just said that this witness is testifying as to how or the thoughts of the members of the community about Blair Rollins. That's total speculation.
I think that issue, the speculation has already been contained, and I think this is getting to the nature of the basis for the reputation evidence. I think sufficient foundation has been laid, so the witness may answer that question.
Ms. Becker, why did he have this reputation?
Because he represented Blair's father, Mr. Rollins, in a trial, and he lost that trial, and Blair's father got sent to jail.
And do you know if you and Blair are approximately the same size and build?
Yeah, I'd say so.
I'm going to ask you a few questions. Was that you in Exhibit 12?
No, not at all. I don't know where Coach Brackman lives.
You ever been to his house?
No, absolutely not. I have no desire to know where my coach lives. The only place I've ever seen him is at mock trial practice.
Did you kill Mr. Brackman?
No, I would never kill my coach. And I don't know who did, but I promise you that I did not kill Mr. Brackman, and I never, ever would have done anything else to hurt him.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor.
You may proceed.
Good morning, Ms. Becker. You were really good at mock trial, weren't you?
Yeah, I was pretty good.
And Miss Becker, your teammate, Miss Cifuentes, testified earlier today that you had this amazing ability to get up on the witness stand and sway the jury any way you needed to. You heard this?
Objection, Your Honor. Improper character evidence.
Any response?
Yes, Your Honor. First of all, the statement is already in evidence. Second of all, character evidence is admissible under Rule 404 to prove motive, intent, or opportunity. In this case, this character evidence is going to Avery's or Miss Becker's opportunity.
And do you believe this is character evidence, counsel?
Yes, Your Honor, I do. I believe she's going to show that Miss Becker could sway the jury on mock trial and is going to show that she acted in accordance with that today and is trying to sway the jury. And to the exception of the hearsay rule, that goes to crimes and wrong acts. And this is not character evidence of a crime or wrong act. Rather, it is just character evidence under Rule 404A. So that is not an exception to this rule.
Any reply?
I'm not sure I understand opposing counsel's response as Miss Becker is on trial for a crime today.
That's true. We will allow the testimony. It goes to the motive and propensity of the witness. You may proceed.
Thank you, Your Honor. Miss Becker, you heard Miss Cifuentes' testimony that you could sway the jury any way you needed to.
Yes, I did. And it's completely absurd because I've been on the trial team for.
Thank you, Miss Becker. My next question is that you actually won awards for your ability to persuade the jury. Is that right?
I had a natural knack for mock trial, but I would never lie in the seat today.
You said that you could get a jury like putty in your hands. Is that right?
Objection, Your Honor. Relevance.
Response?
Yes, Your Honor. Similar to my previous questions, I'm showing the motive and opportunity of Miss Becker.
Court finding goes to the witness's credibility of her testimony here today. You may proceed.
Thank you, Your Honor. Miss Becker, you said you could get the jury like putty in your hands.
I had a natural knack for mock trial, but
thank you, Miss Becker. Despite the awards that you won, Brockman was constantly criticizing your work.
He criticized all of our work. It's how we got better. That's what a coach does.
Miss Becker, he demoted you from A team to B team as a senior, right?
Yeah, it was mainly because of my work ethic. He couldn't understand that mock trial.
Sorry, that was a yes or no question. That's all I was looking for. Moving on, after he demoted you, you did everything you could to convince Brockman to put you back on the A team. Is that right?
Well, yeah, Taylor Perkins, actually my best friend, she stepped down because she didn't really like mock trial.
Miss Becker, thank you.
Interrupting my witness, she is trying to respond and is being cut off continuously.
Any response?
Yes, Your Honor. The questions I've been asking are all yes or no questions. And I am giving the witness, a chance to answer, give some context, but I do feel that I need to move on from question to question. And so I do apologize if I'm cutting the witness off too much, but I'm just trying to move on with my questions.
Yeah. So please don't step on the witness's answer, but the witness does need to confine her testimony to be responsive to the questions that are asked. And counsel, if you can be clear in your questioning that you're asking something very specific, we can move along.
Absolutely, Your Honor. Ms. Becker, at the regional mock trial tournament, you won the Best Attorney Award. Is that a yes?
Yes, I did.
And despite winning this award, Brockman was still criticizing your work, wasn't he? Yes?
I don't think he was criticizing my work. I think he was more just insulting me personally.
Right. He said you did not deserve the award.
He did say that in front of my whole team.
And this made you very angry, didn't it, Miss Becker?
I was humiliated and upset, but
Miss Becker, in your statement, you said that this instance made you really angry, didn't you? Is that a yes?
Is there an objection?
Yes, Your Honor, to hearsay, she's using the witness's statement, which is an out-of-court statement being used for the truth of the matter asserted. If she is trying to impeach my witness, then I ask that she go through the proper steps of that.
I think you go ahead, counsel.
Yes, Your Honor. I'm not trying to impeach the witness. I'm just trying to get clarification as to the witness's testimony here today.
Okay. The witness may answer that question.
Okay. So Miss Becker, my question was, this made you really angry, didn't it?
naturally it made me angry just because I felt like I was being insulted. And
right. Miss Becker, next question. You were so angry that you called your coach the worst coach in the state.
I admit that I said some things that I know aren't true.
Thank you, Miss Becker. Miss Becker, you were so angry that you stormed out of practice that night?
I didn't want to keep being insulted anymore.
Okay, and when you walked out, you recall seeing what you called Brackman's obnoxious white Porsche?
I mean, he would always in practice brag about how fast it could go, you know? The license plate even read litigator.
And you knew, you just testified to it, but you knew that Brackman loved this car, right?
I mean, he would brag about it a lot.
So you took a permanent marker and wrote in giant letters across the hood of the Porsche, Worst Attorney Award. Is that right, Ms. Becker?
Objection, Your Honor. Improper character evidence.
Comments?
Yes, Your Honor. This incident is not improper character evidence because it is not being offered to prove that Ms. Becker acted with a certain trait on the day of the murder. Instead, it is simply being offered to demonstrate how angry Avery was at her coach. It goes to both motive and intent.
Any reply?
It actually is going to show that she acted in accordance with this. The prosecution is trying to prove that she vandalized Mr. Brackman's home. So by them testifying that she vandalized his car, they are going to show that on a particular occasion, she vandalized his home, which is improper character evidence.
And the court finds that this is not character evidence, rather it is actions by the defendant, and goes to motive and state of mind, all of which are relevant to these charges. The witness may answer, and counsel, you may proceed.
Thank you, Your Honor. So, Ms. Becker, you damaged your coach's personal property.
I swear, I thought it was a dry erase marker. I really did. I thought that,
but
you know.
Did?
Yes, I did. I later learned that it was a permanent marker. And I'm so sorry for what I did.
Thank you, Ms. Becker. When Brackman saw what you had done to this beloved Porsche, he kicked you off of the mock trial team, didn't he?
Yes, he did.
So he was pretty upset about what you did to his car.
He seemed pretty furious. I mean, he yelled at me.
But despite this, he did not press charges.
No, he didn't.
But Ms. Becker, that's because he was murdered before he could press charges. Isn't that right?
No, absolutely not. I don't know why Mr. Brackman didn't press charges, but I'm sure glad that he didn't.
Ms. Becker, the night of the vandalism incident, you had a conversation with your mom, right?
Yes, I did. I went home to go vent to my mother.
But you failed to actually tell her that you had vandalized the car?
I was embarrassed. And I didn't really want to talk about it, but I did tell my mother.
But Ms. Becker, what was that? Sorry.
Oh, I think we have a failure to communicate.
Okay. Ms. Becker, what you did tell your mom was that you would get back at Brackman, Mackenzie Brackman, if it was the last thing you did. Is that right?
I was simply just venting at her. I would never carry that out. I was just in the heat of the moment.
Ms. Becker, did you say this?
I did, but I didn't mean it.
Thank you, Ms. Becker. So let me just get this straight. You make this statement, and then Mackenzie Brackman is found murdered. Is that right?
I would never murder my coach, ever. The only thing I ever did to him was what I did to his portion. I feel so ashamed about what I did.
Ms. Becker, in this instance, you were clearly very upset with Mr. Brackman, weren't you?
I'm angry enough to murder him. No, I would not murder him.
But, Ms. Becker, moving on, to make matters worse, Brackman refused to talk to you after you vandalized his beloved car. Isn't that right?
Yes, he did. And
this upset you?
Because now he's dead. Someone murdered him, and I'll never be able to apologize to him.
Ms. Becker, you said that Brackman's refusal to talk to you devastated you, didn't you?
Well, I'm upset because now he's dead, and I'll never be able to express how truly ashamed I am.
Thank you. Moving on, Ms. Cifuentes testified today that you texted her shortly after you were kicked off of the mock trial team. She testified that you texted her, if he's still upset about his car, just wait until he sees what I do to his house. You heard this, Ms. Becker?
Yes, it is absolutely absurd because I can promise you that I did not send those text messages.
Thank you, Ms. Becker. Ms. Cifuentes also testified that you texted her, I'm going to wait until he's at work, then break in and trash the house. You heard this?
Yes, but I did not send those text messages. I promise you.
That's right. That's right. You deny sending these texts, right?
Because I didn't send those texts. I can promise you that.
Well, you deny, Ms. Becker, you deny sending these texts because you allegedly lost your phone on the day of the murder. Is that right?
I didn't. I don't know when I lost my phone, but the last place I saw it was actually the day before the murder on March 5th when I gave it to Alex.
On the day of the murder, you claimed to have been with Miss Taylor Perkins?
Yes. Taylor and I were with each other the whole day.
Earlier, you testified that you and Miss Perkins were best friends. Is that right?
Yes, we were best friends.
You would go to Miss Perkins if you ever needed anything.
Well, I mean, it was Taylor's idea to step off the mock trial team because she felt bad for us.
Miss Becker, can you answer my question? My question was, you would go to Miss Perkins if you needed anything because you were best friends.
Well, we were best friends. I felt like I could talk to her about a lot of things.
Thank you. And Miss Perkins is the only one here today who can confirm your alibi on the day of the murder. Is that right?
Yes, but we were with each other the whole day.
Thank you, Ms. Becker. No further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor, briefly.
You may proceed.
On cross-examination, you were asked about the way you swayed the jury. Can you explain that?
Well, as an attorney, I just had a natural knack for crosses and closings especially. I would just kind of smile at the jury and they knew that I understood the case well, but I would never lie on this seat today.
And you were also asked about vandalizing Mr. Brackman's car. Did you think that was a permanent marker?
No, absolutely not. I thought it was a dry erase marker because I was about to go up to the whiteboard to write everything that I had done good at the tournament. And then Coach Brackman began to say some deplorable things to me. And so then when I left, I still had it in my hand. I didn't know it was a permanent marker.
You were cut off while you were talking about what you said to your mom. Can you please explain that?
Yes, well, I went home to my mom and I was venting to her because I just couldn't believe that was how my mock trial career ended. I mean, it was so crazy, but I would never carry that out, ever.
Did you kill Mr. Brackman?
No, absolutely not. I would never kill my coach, and I don't know who did, but it was not me.
No further questions, Your Honor.
Thank you, counsel. Any recross?
No, Your Honor. I don't think it's necessary.
Thank you. The witness may step down. Defense may call their next witness. And that's going to be?
Defense calls Taylor Perkins.
Ms. Perkins, you'll recall that you are still under oath. Counsel, you may proceed.
Ms. Perkins, do you know the defendant, Avery Becker?
Yes, I do. We were best friends during high school. I love Avery.
Where did you attend high school?
We both went to CHS. That's Colorado High School.
And while you were at CHS, what sort of extracurriculars did you do?
Well, among other things, I mostly just did mock trial with Avery. It was really fun to hang out with her after school.
And how long were you on the mock trial team for?
It was about 4 years. I did step down in my senior year, right before regionals.
Ms. Perkins, I now want to ask you some questions about Coach Brackman and Ms. Becker's relationship at that time as you perceived it for nearly 4 years. What was their relationship like?
Well, from what I saw, Coach was always giving Avery a hard time about something, usually about her preparedness or practice. But to be honest, the more you know, the less you need to say. I mean, Avery didn't have to prove that she was great. She just was.
Were there any specific incidents where you recall them having an issue?
Yeah, there was this one time that Coach demoted Avery down to the B team for basically no reason. They kind of had a feud.
What happened next?
Well, once Avery was demoted, I stepped down off the team. I really wanted to support Avery, plus I didn't really care that much about mock trial anyway.
Did Miss Becker ever get back onto the A team?
Yeah, once I stepped down, she was put back on. I think Coach knew they couldn't survive without her. I mean, she was probably the best lawyer on the team.
What happened next?
Well, the team won regionals and Avery won a bunch of awards. They were really great. I was sort of sorry I missed it, but I'm not super passionate about being a lawyer or anything, so it was all right.
I now want to ask you about March 5th, 2020. Did you see Miss Becker this day?
Yeah, I totally did. Me and Avery were hanging out that day. She had come over to my house and then we went to the Fry Shack.
Who was at the Fry Shack that day?
Well, the Fry Shack is sort of like a popular hangout spot for the local mock trial teams, and basically CHS. While we were eating there, the team showed up. I should have known. They go there after practice.
Do you recall seeing Miss Becker have her phone that day at the Fry Shack?
Yeah, I definitely do. Avery had her phone at the Fry Shack. The last time I saw it was on the table.
What happened next?
Well, Avery got up and went to the bathroom. At that point, Alex Fuentes was at our table.
Where do you remember the cell phone being while Miss Becker was in the bathroom?
It was definitely on the tabletop, but I didn't see it after that.
What happened next?
Well, Avery came back. We said bye to Alex and we went to the mall.
And at the mall, did you see Miss Becker on her phone?
No, I don't really recall seeing Avery on her phone then. The last time I saw it was at the Fry Shack.
You just said you saw Alex Fuentes at the Fry Shack. How do you know Miss Fuentes, excuse me?
Alex was on the mock trial team with us.
From what you perceived, were Miss Becker and Alex Fuentes friends?
Well, you know what they say, you catch more flies with honey than vinegar. I mean, if Avery was a fly, then Alex was definitely the vinegar. Maybe on the surface, they were polite to each other, but deep down, not so much. From what I observed, Alex was always jealous of the roles that Avery got on the team.
Do you know of a person named Blair Rollins?
Yeah, I do. He was a student at CHS.
What was Mr. Rollins' reputation at CHS?
Well, Blair sort of had a reputation about the community for being the kind of guy that could totally kill someone and not even think twice about it.
What else was known about Mr. Rollins' reputation?
Well, I would also say that it was known in the community that Coach Brackman represented Blair's dad in a criminal law trial.
Yes, Your Honor.
Hang on, was there an objection?
Yes, Your Honor, there was. Lack of foundation. I'm not opposed to opposing counsel asking this question. However, I ask that she lay a little more foundation as to how this witness knows about Mr. Rollins' trial.
All right, any response?
Yes, Your Honor. Ms. Perkins has clearly stated this was common knowledge through Mr. Rollins' reputation at CHS and known by many that his father was represented by Coach Brackman at his criminal trial and later lost that trial. Ms. Becker has already testified to this matter, and so I feel the proper foundation has been laid.
Any reply?
Yes, Your Honor. With the opposing counsel's explanation of foundation, I do accept that. However, with her saying that this was common knowledge, Ms. Perkins was not at this trial and therefore would have had to hear about this trial from someone else, therefore making this entire statement hearsay due to the fact she was not at the trial and must have heard about it from someone.
May I respond, Your Honor?
Yes.
Under 803.21, a person's reputation among that person's associates or in the community concerning that person's character is excluded by the hearsay rule. Here it is Mr. Rollins' reputation at CHS about his father. It is not hearsay.
The court will allow the testimony. The foundation has been sufficient as to this witness's understanding for the basis, and so it'll be allowed, and counsel may proceed. Thank you.
Ms. Perkins, please elaborate a little bit more on what you know about Mr. Rollins' reputation at CHS.
Well, as I said, the CHS community sort of knew that Coach Brackman represented Blair's father in a criminal trial, and Coach Brackman lost that case, at least from what I've heard. And I think that Blair definitely didn't like Coach because Coach was the one who put his father in jail.
Let's move on to March 6, 2020. Where were you this day?
I was with Avery. We were looking for her phone. It had gone missing the day before.
How did you realize that this cell phone was missing?
Well, me and Avery sort of have this routine where she'll pick me up from school sometimes, especially when we have a free period. I had texted Avery that morning to see if she was going to come over to my house and pick me up, but she never responded. She did end up coming that day, but when I got in the car, that's when we realized that her phone was gone.
How long were you with Miss Becker Friday, March 6th?
Oh, the entire day.
And please tell the jury of all the places you went to that day to search for Miss Becker's phone.
Well, we went to the mall. We sort of just went all the places we had been the day before, all the stores. And we went to the Fry Shack twice, once somewhere in the morning, and then again to check on the afternoon shift staff to see if anyone had seen Avery's phone.
What other efforts did you do to help find Miss Becker's cell phone?
Well, I called and texted Avery's phone a few times just to see if we could hear it ringing, but we never found it. It's still missing. I personally think that it was stolen since we never found it anywhere we had been the day before.
Did you go anywhere near Coach Brackman's house that day?
No, we never went near Coach Brackman's house.
Do you even know where Coach Brackman lives?
No, I think it would be kind of creepy if I knew where he lived.
No further questions.
Thank you, counsel. Any cross-examination?
Yes, Your Honor.
You may proceed.
Good morning, Ms. Perkins. If you could please keep your answer to a yes or no, that would be great. Have you known Avery for a long time?
Objection, Your Honor.
Objection?
I would ask that opposing counsel do not direct my witness.
Counsel, you can just go ahead and ask your questions as they come.
Okay. Ms. Perkins, have you known Avery for a long time?
Oh, absolutely. Me and Avery were friends all throughout high school.
So you were incredibly close friends with Ms. Becker?
Yeah, I would say we were best friends. We hung out a lot, especially on mock trial.
You joined the mock trial team just because of Ms. Becker?
Yeah, I mostly joined to hang out with Avery, but it was a fun thing to do after school.
Throughout the amount of time that you spent at mock trial, you observed the relationship between Mr. Brackman and Ms. Becker?
Yeah, I did. It was somewhat rocky, to say the least.
So you observed their fighting and the tension?
Well, I would say they had a feud, but not necessarily a fight. There was often tension, but it wasn't too bad. Enough for Avery to play some pranks on Coach, but it wouldn't have escalated beyond that.
Thank you. Ms. Perkins, you ended up stepping down from the mock trial team for Ms. Becker, correct?
Well, I mean, I did join for Avery, so if Avery wasn't there anymore, then why would I be on the team? I mean, who am I going to hang out with? Alex? I don't want to do that.
Your Honor, may I ask this witness to please answer my question?
Yeah, the witness is straying a little bit far from the questions as answered, and this is cross-examination, so please respond to the question as asked and explain if you have to, but I think these are direct questions.
Ms. Perkins, did you step down from the mock trial team for Ms. Becker?
Yes, I wanted to support her.
So you're an incredibly loyal friend?
I mean, I wanted to support my friend. Of course, friends are supposed to be loyal. That's what friends are for.
Ms. Perkins, you were not at school the day that Mr. Brackman was killed, correct?
No, I was with Avery the entire day.
And you spent that time looking for Avery's phone.
Yes, we did. It had gone missing, like I said.
Where did you look for Miss Becker's phone?
The mall, the fry shack, twice, like I said. That was the only places we had been the day before.
Yet you stated on direct that you only recall seeing Miss Becker on her phone at the fry shack and not after that. So why did you look at the mall?
Well, to be honest, I wasn't sure if it went missing at the fry shack or at the mall. We just wanted to cover all our bases. You know, you miss 100% of the shots you don't take.
Thank you. You said you spent the entire day looking for the phone, correct?
Yeah, we did. We never found it,
Thank
though.
you. And you texted and called the phone while trying to look for it?
Yes, we were trying to hear it ringing.
Yet throughout the entire day that you spent looking for the phone, you only called it 5 times.
5 times? I mean, we called it a few times. I don't think I specifically stated a number.
It was 5 times. And Ms. Perkins, you did state on direct that you were nowhere near Mr. Brackman's house.
No, we never went to Mr. Brackman's house, only the mall and the fry shack while looking for Avery's phone.
So you said you were nowhere near Mr. Brackman's house. How did you know you were nowhere near Mr. Brackman's house?
Well, to be honest, I don't know where Mr. Brackman lives. I only meant that we were never there, which we weren't.
Right, but you did say you were nowhere near Mr. Brackman's house, yes or no?
Yes, because we weren't, but I don't really know where his house is.
And Ms. Perkins, so prior to testifying today, but after Mr. Brackman was murdered, you spoke to the defendant, Miss Avery Becker?
Yeah, I mean, it was shocking that Coach was murdered. Of course, I spoke to Avery about it.
And in this conversation, the defendant brought up the idea that Blair Rollins may be involved. Yes or no?
Yes, she did. And I do believe that is what happened.
So the defendant in this case, the only suspect on trial, introduced you to the idea that there could be someone else who committed this murder. Yes or no, Ms. Perkins?
Yes, it makes a lot more sense because our stories are corroborated. Blair doesn't really have an alibi.
Thank you, Ms. Perkins. No further questions, Your Honor.
Any redirect?
No, Your Honor.
All right, thank you. This witness may step down, and the defense may call its third and what I understand to be its last witness. And who is that witness going to be, counsel?
Yes, Your Honor. The defense calls Professor Van Owen.
Thank you. Professor, you'll recall that you are still under oath, and counsel, you may proceed.
Of course, Your Honor.
Professor, could you please introduce yourself for the court?
My name is Professor Blake Van Owen, Vanowen.
Professor, were you asked by the defense to give some expert opinions in today's case?
Yes, I was.
Now, did you reach any opinions?
Yes, 3 in fact.
Before we discuss those opinions, let's first talk about what you do. What do you do for a living?
I am employed as a private investigator for many defense cases, in addition to working as a professor at CU Denver.
Let's talk about your background. Where did you go to school?
I went to CU Boulder, Skull Buffs, where I received my bachelor's. Then I moved on to receive a master's degree in criminal justice from the University of Ashford.
Do you have any specific time with police or work in police practices?
Yes, I worked for the Aurora Police Department for a time, but moved on to working as a PI and a professor.
And what do you do now?
Now I act as a private investigator where I am tendered as an expert in many different areas, including cell tower analysis, crime scene reconstruction, as well as general police practices and procedures. In addition, I am a professor in social justice, as well as general police practices and procedures.
Professor, how do the areas that you've been tendered in the past relate to the case we're talking about today?
Now, all of these past tenderings are highly prevalent in today's case. I like to think of my job as a private investigator as similar to that of a candy maker. A candy maker is responsible to know how to make candy corn, candy cane, and also licorice. Now, although these 3 candies are vastly different, it's pertinent for a candy maker to know how to make these 3 individual things. As a private investigator, these 3 subjects are highly different, but again, it's pertinent for a private investigator to know how to conduct crime scene reconstruction, cell tower analysis, as well as go about a general police procedures and investigations.
Your Honor, I offer Professor Blake Van Owen to be tendered as an expert in the areas of police practices and investigation in crime scene reconstruction and cell tower analysis pursuant to Rule 702.
Thank you for that tender. Any objection or voir dire?
Your Honor, before anything, could I have a brief time check for my co-counsel?
Sure. Timekeepers, last note I have is 9 minutes remaining. I'm not sure if that's still accurate.
Your Honor, if you were referring to the defense direct, then I currently have 809. And if you were referring to the prosecution cross, then I currently have 706.
Okay, thank you.
No objections at this time, Your Honor. Any issues with credibility will be addressed on cross.
Okay, so the court will accept this witness as an expert in police practice and procedures, crime scene reconstruction, and cell tower data analysis. Counsel, you may proceed.
Professor, you said that you reached some expert opinions. What were they?
My first opinion is that we can't place Avery Becker at the scene of the crime on March 6th. Second, we have no accurate knowledge as to what truly occurred inside of the home of Mackenzie Brackman on March 6th. And finally, the prosecution's investigation was sloppy and ill-performed.
Let's talk about your first opinion. Did you hear the testimony of Detective Markowitz as it pertained to cell tower analysis?
Yes, I did. I believe Detective Markowitz described cell tower analysis as a way to provide a quote, general picture of someone's location. And that is an egregious understatement.
What do you mean?
Now, how cell tower analysis really pinpoints someone's location is it provides a large area, in today's case, 37.7 square mile area, in a certain radius arc, and this radius arc being 120 degrees. So the only thing we can conclude about Avery Becker's phone is that it was in this 37.7 square mile area inside of this 120 degree arc. We can't place Avery Becker at the scene of the crime.
Professor, you also mentioned opinions about March 6th, 2020 inside Mr. Brackman's home. Did you review Kyle Kuzak and Detective Markowitz's investigation as it pertained to the crime scene?
Yes, I did.
And do you agree with their findings?
No, I do not.
Why is that?
Miss Kuzak believes that when the crime occurred, it was a burglary gone wrong. This is far from the truth. In fact, the CSR data reflects a premeditated invasion where the intruder brought a knife to the scene and surprised Mackenzie Brackman, stabbing him in the back.
What evidence supports your claim?
I'd like to go through a couple things. To start, a couple pieces that Ms. Kuzak pointed out that she believes contradict my beliefs. I believe there were 5 different grounds. To start, the scuff marks. The scuff marks were made directly inside of the door. We have no way to date scuff marks. These could have been made from furniture. Perhaps Mr. Brackman was moving furniture inside and out of his house. These could have been made from high heels from Mackenzie Brackman's girlfriend. We have no knowledge as to how these scuffs were created. Secondly, the knife. The knife is a different make, model, style, and brand from those found at the scene of the crime in the knife block of Mackenzie Brackman. Now, I believe it was the exact dictation of Detective Markowitz that the knives were just like the one retrieved from the body. That was a lie.
What other evidence supports your belief?
Well, if we look specifically at the coroner's report, as well as Exhibit 12, the coroner's report outlines the incision and the stab wound of Mackenzie Brackman. Now, this stab wound illustrates that the knife was inserted at a very straight angle. What this means is that it could not have been created in a bear hug. Now, this is because when someone is engaged in a bear hug with another person, their wrist would be inverted, thus creating a stab wound that has an angled stab rather than a straight on. Now, the straight on incision is more in accordance with being stabbed from behind in such a manner of being surprised. In regards to the scuff marks as well as those, there's no evidence that clearly indicates a struggle.
What does this lead you to believe about how the intruder wanted to kill Mr. Brackman and why?
Ultimately, this leads me to believe that the intruder brought the knife on scene and attempted to kill Mackenzie Brackman, not simply attempting to burglarize.
Do you have any other evidence that supports your claim?
Yes. In regards to the Exhibit 12 that we saw earlier, This directly goes against the scuffle. When the intruder opens the door, they enter freely, not met with any resistance. Thus, it is far more likely that they entered silently and they were able to surprise Mackenzie Brackman, furthering that he was surprised and stabbed in the back.
You also mentioned that the prosecution conducted a poor investigation. What do you mean?
There are 3 grounds for this. To start, you already heard about how the prosecution's investigators lost a piece of evidence. Next, the reliance on a questionable document, that being Exhibit 14, the text messages. And finally, their lack of ability to look at any other suspects for today's case, zeroing in on a single high school student, Avery Becker.
Professor, I'd first like to talk about those screenshots that you just mentioned. Why does that indicate a poor investigation, in your opinion?
Now, Detective Markowitz outlined her ability to use Celebrate and obtain cell phone records off someone's cell phone remotely. This would have been able to recover these text messages directly. However, Detective Markowitz failed to do so by choice or lack of care. I am not sure. But this would have this would have outlined the authenticity of these text messages. However, we have no knowledge as to whether they were truly sent by Ms. Becker in today's case.
Professor, I'd also like to move to what you said about Detective Markowitz honing in on one suspect. What did you mean?
Now, I'd like you to understand, when you approach this case, you have to recognize that Mackenzie Brackman is a defense attorney. He represents criminals being charged with some egregious acts. Now, going into this, he had a clear a clear idea that it's quite possible that this could be a disgruntled ex-client. However, he narrowed in on a high school student that killed their coach of an extracurricular activity. It's as if Detective Markowitz was in a field in Kansas. He hears hoofbeats around her, and she thinks to herself, hoofbeats must be zebras. It makes no logical sense.
Detective Markowitz, did you follow any leads that Detective Markowitz failed to follow?
Yes, I did. I investigated Blair and Jonathan Rollins.
And did you find anything credible?
Yes, I did. I found that Jonathan Rollins was tried for murder, and he lost his case. He was defended by Mackenzie Brackman.
Sorry, there was an objection? What's the basis?
Relevance, lack of personal knowledge, and lack of foundation.
Response, counsel.
Your Honor, the foundation has been laid and the stipulated fact has been made that Jonathan Rollins was convicted at a murder trial and that there was a recording made at that murder trial. Professor Van Owen has testified that he has personal knowledge of the murder trial through his investigation, and therefore he is not speculating, and the foundation has been laid that he can testify to this topic.
Any reply?
Your Honor, I recognize that Blair Rollins is being offered. However, I don't see how the mention of Jonathan Rollins is relevant, seeing as the relationship between Jonathan and Blair is not provided by the defense. By all we know, Blair Rollins could be estranged from his father and have no effect on the purported motive.
All right, those are points that are proper for cross-examination, but as to relevance and foundation, those have been established. This testimony goes to motive to the potential other suspect involved, and foundation has been established previously, so the testimony will be allowed. But you can address those on cross-examination if you'd like, counsel. You may proceed.
Professor, when you looked into this lead about the trial, what did you find?
Now, I found that Blair Rollins testified on behalf of his father. Now, this meant that Blair was present for the trial and the hearing. Now, as you heard earlier, as Jonathan Rollins is being escorted to jail, he shouts to Mr. Brackman, "I will get you back, Brackman, if it's the last thing I do."
Professor, I will play the exhibit once more, and please confirm that this is the recording you heard.
Of course.
I'll get you back, Brackman, if it's the last thing I do.
Professor, is that the correct recording?
Yes, that is.
And what did this lead you to conclude about the prosecution's investigation?
Ultimately, the prosecution's investigation for someone who spent their entire life fighting for justice, it's a crime, to say the least. They're tarnishing this man's legacy who fought for justice his entire life and making a mockery of justice.
Your Honor, thank you. I have no further questions.
Thank you, counsel. Cross-examination.
Yes, Your Honor. Permission to proceed?
You may proceed. Thank you.
Good afternoon, Mr. Van Owen. I'd like to talk about your history in this line of work.
I apologize.
Thank
It's Professor Van Owen. I've earned the title and would appreciate it if you could respect that.
My apologies, Professor Van Owen. You formerly worked at the police department?
Yes, I worked at the Aurora Police Department.
In the mere 9 months you worked for the PD, you were sued by a woman for assault.
Yes, I was sued. However, I was cleared of any criminal wrongdoing.
Right after this assault suit, you left the PD entirely.
Yes, it made me realize that some of the forces
You
employed
left the
by
PD.
police department were not, excuse me, what?
You left the PD.
Yes, I did.
And today you are testifying against police officers.
That is true, yes.
Objection, Your Honor. Improper character evidence pursuant to Rule 404B2.
It's cross-examination. Goes to credibility. You may proceed.
Sorry, could you ask that question again?
Today you are testifying against a police department.
No, I don't believe so.
You are not testifying against Detective Jordan Markowitz and Kyle Kuzak?
No, I am testifying for Miss Avery Becker. I'm here to tell the truth and to shed light on what truly happened on March 6th.
Okay. You left the police department with a chip on your shoulder, and now you're testifying against 2 police officers.
No.
Okay. I'd like to transition to your career as an investigator, specifically with regards to payment. You charge $225 per hour for your investigation work?
Yes, I do. I get paid to work.
You charge $450 per hour for in-court testimony?
Yes.
Your payment doubles just by stepping in a courtroom.
Yes, it does.
Is that because in a courtroom, you are under penalty of perjury?
No, ma'am, just as you are paid in a courtroom, I also am paid. Testimony just provides more preparation, and therefore it requires more payment.
In a courtroom, you are under penalty of perjury where you get paid more.
That is a true situation. However, that's not the reasoning.
All right. Let's talk about the facts at hand. You disagree with the prosecution's theory that there was a struggle during the crime?
Yes, I do.
You believe that ring alerts and scuff marks are unreliable indicators of a brawl?
I believe the nature of the prosecution's investigation leads to unreliability in that regard. We have no evidence to uphold the authenticity of either of those claims.
Now, it is your job to analyze evidence for the police, correct?
To an extent, that is part of my job, yes.
And you heard both experts testify to a broken plate on the scene?
Yes, of course.
And yet, this broken plate is left out entirely from your report?
I would be glad to give you an explanation as to why it could be there, if you'd like.
No need. I'd like to transition to a different aspect of your story, specifically the alibi. It is your belief that Taylor and the defendant were out looking for a phone?
Yes.
Cell tower records of Taylor Perkins' phone could confirm this supposed theory.
Yes, that's true.
You had the ability to obtain these records of Taylor Perkins' phone?
I did. However, it's not my job to provide the burden of proof. That is the prosecution's job.
You didn't bother to present this evidence on behalf of a defense witness to the jury today.
Again, it's the prosecution's job to disprove my client's alibi. It's not
It is not in court today.
Yes, and I believe that is to the prosecution's detriment.
Okay, while we're on this topic, let's talk more about the cell tower records you did decide to look at. Could I direct you to Exhibit 16? If you have a copy in front of you. All right. Now you claim that these are inconclusive of the defendant's phone's location?
In what regard, may I ask?
That cell tower reports cannot conclude that someone's location.
Not truly accurately, no. It gives a general area.
They somewhat jump from tower to tower?
Yes, based on traffic, location, a number of different things.
If you could confirm with a yes after each statement, I'm just going to read the time and location of each record on this map.
Of course.
1247, cell Objection, tower near Your the...
Your
Honor,
objection, hearsay. Exhibit 16 has not been entered into evidence. The opposing counsel is reading an out-of-court statement.
Any response?
Your Honor, my apologies. I'm referring to Exhibit 15. This has been entered into the evidence for the jury to review today.
Do you still have an objection, counsel?
Yes, Your Honor, I believe she was reading out of Exhibit 16. Exhibit 15 has been entered into evidence. I just want to confirm that we're referring to the entered exhibit.
That's my understanding. Is that true, Counsel?
Yes, Your Honor.
Okay. So with that, no, I gather the objection is withdrawn?
Yes, Your Honor.
Okay. You may proceed, Counsel. Thank you.
1247, cell tower near the defendant's house.
Yes.
1255, cell tower near a major intersection.
1191, yes.
105, 106, and 117, cell tower near Mackenzie Brackman's house.
I'm not seeing those times on that final one.
13
yeah. My apologies. I see those now.
Were those times all in chronological order?
Yes, it appears so.
And Professor Van Owen, you believe this chronology is due to coincidence alone?
No.
Thank you, Professor. Your Honor, no further questions at this time.
Thank you, Counsel. Any redirect?
Briefly, Your Honor, first may I ask how much time I have left?
Last I see is 20 seconds, timekeepers. Is that right?
You have 19 seconds remaining.
Thank you.
Professor, briefly, you were asked about a broken plate at the crime scene. How can you explain this broken plate?
We have no knowledge as to how this was created. It could have been created when Mr. Brackman was stabbed and he was moving towards his front door. Could have been created prior to the crime. We have no knowledge as to how it was made.
Thank you, Your Honor. I have no further questions.
Any recross?
No, Your Honor.
Okay. Thank you very much. The witness may step down. I was under the impression that was the last defense witness. Does the defense rest?
Yes, Your Honor. At this time, the defense rests.
All right. We'll move to closing arguments. Prosecution, when you're ready, you may proceed.
Yes, Your Honor, and I just want to check, is any time not used in this first segment can be reserved for rebuttal?
Yes, you've already asked that, and I'm going to ask the timekeeper at the finish of your opening section of closing to let me know how much time remains. You may proceed.
Mischief was intended, in murder it ended. Members of the jury, allow me to take you back to a scene that my co-counsel Miss May mentioned in her opening. It's 3 o'clock on a Thursday, and Avery Becker furiously storms into the kitchen. See, despite being an expert in swaying the jury, her mock trial coach has ridiculed her efforts. Coach Brackman's criticisms have gotten worse, and she's had enough. After Coach Brackman demoted and removed the defendant from the team, she boiled in rage, climbed to the top of his car, and wrote in bold permanent marker across the hood, "Worst Attorney Award." But to her, this wasn't enough. As she hides away the Sharpie, the defendant texts her friend Alex, telling her plan to break in to Mackenzie Brackman's house and once again vandalize his belongings. Her eyes are tearful with anger. The defendant's mom enters the kitchen to ask what's wrong, to which the defendant responds, "I'll get back at him if it's the last thing I do." Today, the prosecution has proven beyond a reasonable doubt that the defendant committed second-degree burglary and first-degree murder. We have proven that the defendant knowingly and unlawfully entered the dwelling of Mackenzie Brackman with intent to commit criminal mischief. While in this dwelling, the evidence proves that the defendant, during a burglary, caused the death of Mackenzie Brackman. To break that down, mischief was intended, in murder it ended. The prosecution holds the burden of proving the defendant guilty beyond a reasonable doubt. Please remember that reasonable doubt is not based upon any possible or speculative doubt. Reasonable doubt must be based on the cumulative evidence presented. Looking at this case as a whole, the prosecution has left no reasonable doubts. The defendant demonstrated intent to break into Mackenzie Brackman's house. Alex C. Fuentes read the vengeful text wherein the defendant states, "I'm going to wait until he's at work, then break in and trash his house." That'll show him. Less than 24 hours later, a person masked and gloved with the same height and build as the defendant is seen at Brackman's house. Detective Kyle Kuzak presented video evidence of this intruder as she is seen breaking in through the back door, just as the defendant said she would. Upon entering, the defendant came face to face with Mackenzie Brackman. A confrontation ensued. Brackman was stabbed and the defendant fled the scene. Detective Jordan Markowitz testified to evidence of this struggle firsthand with a broken plate, a flipped chair, and Mackenzie Brackman dead on the floor in a pool of his own blood from a fatal stab wound. During this time, Alex Cifuentes sat in class, Avery's empty seat beside her, and wondered why she wasn't in school that day. But members of the jury, you know where she was. Detective Markowitz testified to cell tower records placing the defendant's phone at Mackenzie Brackman's house the same day of the murder. She drew a clear line of that path. I challenge opposing counsel to answer the question, where is the defense's line? What is their common thread? The prosecution has proven their answer to be quite simple. They don't have one. Today, we look back at Avery Becker in the kitchen, fired up after vandalizing her coach's car, planning her next move. This time, her attack is more permanent than a Sharpie. Mischief was intended, in murder it ended. Members of the jury, the defendant, while unlawfully entering Mackenzie Brackman's home, caused the death of Mackenzie Brackman. Find her guilty. Thank you.
Thank you, counsel. Timekeepers, how much remains?
58 seconds, Your Honor.
58 seconds. Thank you. Counsel for defense, you may proceed.
Yes, Your Honor. I'd like to simplify the prosecution's arguments that you just heard. You just heard a story about a high school girl who was apparently so upset about an extracurricular activity that she decided to kill her coach, whom she knew well. That is all the prosecution has. And as a result of a rushed investigation, they're willing to put a high schooler in jail for the rest of her life. This is a mockery of justice. Now, the prosecution just arrived at some speculative conclusions about the events of March 6th, and I'd like to talk about them. The prosecution first wants you to believe that Ms. Becker was so upset that she drove to her coach's house to vandalize it. Then they want you to believe that Mr. Brackman didn't call 911 and instead armed himself with a knife. Then they want you to believe that once inside, Ms. Becker, a high school girl, got control of the knife from her coach, a middle-aged man, and stabbed him in the back. Then Ms. Kuzak wants you to believe that Ms. Becker fled the scene and Mr. Brackman was forced to pull the knife out of his own back. Members of the jury, that morass of speculation is what you heard. And it's also what Professor Van Owen was presented with. As you heard, he outlined the inconsistencies in the prosecution's case and told you how it was probably a premeditated event. He discussed how the prosecution relied on Ms. Cifuentes' screenshots that could have been faked or created. You heard today that Ms. Cifuentes had exclusive access to Ms. Becker's phone the day before the murder, March 5th. You also heard that Ms. Becker had never seen those text messages before. And if you thought not investigating all evidence was bad enough, you saw that Detective Markowitz moved the victim between taking pictures of evidence. Furthermore, Kyle Kuzak and Detective Markowitz both lost the same images that would have given us a clearer picture of where Mr. Brackman was murdered. Was he murdered in a fight by the back door, or was he murdered sitting down? Because of their investigation, we don't know. But what we do know is that every piece of evidence presented to you, members of the jury, by the prosecution was done so in a selective manner. The prosecution knows that cell towers are not reliable pieces of evidence, but they chose not to tell you. They know there's another suspect, Blair Rollins, who had a reason to kill Mr. Brackman, but they chose not to investigate and they chose not to tell you. Instead, they pushed their own narrative and made a complete mockery of justice. Members of the jury, I'd like to remind you that Detective Markowitz doesn't determine who is guilty. Kyle Cusack doesn't determine who is guilty, and neither does Professor Van Owen. Instead, you are the sole arbiter of this case. You, members of the jury, determine who is guilty and who is innocent. Now, you were just read the jury instructions. I'd like to focus your attention on instruction number 8. You must find that Ms. Becker knowingly went to her coach's house with the intent to commit criminal mischief. I'd also like to direct your attention to instruction number 2, which says the prosecution holds the burden of proof. You must find these elements beyond a reasonable doubt. So, ask yourself, do you have any doubts that Miss Becker was the killer? Now, we don't know who went to Mr. Brackman's house on March 6th. We don't know who killed him. What we do know is it was not this high schooler. There is doubt everywhere you look. The prosecution only intended to look into one suspect, and in a mockery of justice, it ended. Thank you.
Thank you, counsel. Prosecution, you have 58 seconds remaining for your rebuttal section. You may proceed when you're ready.
Thank you, Your Honor. Members of the jury, let me remind you that premeditation is not required for the defendant to be guilty of felony murder. A death caused in the midst of a felony is still first-degree murder. Therefore, if you find Avery Becker guilty of burglary on March 6, 2020, you must also find her guilty of murder. The defense attempted to offer a careless investigation. Let's talk about that. Let's talk about Professor Van Owen's inability to include a broken plate, witness cell tower reports, and logic of time chronology in his analysis. The defense has answered the question I left them with. Their case has no common thread. Their case has no line. Mischief was intended, in murder it ended. Find the defendant guilty. Thank you.
Thank you, counsel. The case is now submitted to the jury panelists for them to fill out their forms. I understand that the panelists are asked to remain online after submitting the scores until the court is dismissed and all the scores are confirmed back at tabulation. If you could do that, that would be much appreciated. And if my courtroom monitor can let me know when those scores are fully submitted, we can offer some comments. Thank you.
I will, Your Honor. You may begin feedback to the participants while the panelists are submitting their scores if you'd like to.
I'm going to wait for just a moment and give the panelists a chance to get their scores in.
The panelist scores are confirmed.
Thank you. I'm going to congratulate both teams on a terrific round. This was a ton of fun. I hope you all enjoyed the season that is well, we're nearing the end of. You've clearly put in a ton of work and really mastered the facts and the presentation skills. This was an absolute pleasure to watch. I know you're probably eager to move on. I'm just going to offer a few highlights. Just for me, the highlight of the trial was probably the last witness, Mr. Van Owen. Thomas, I thought you filled out the role of a slightly smug expert remarkably well. That was very convincing. And Michael, you've got a great command, a great organization. The signposting was terrific as you got through this witness. And you've learned a skill that a lot of trial lawyers have a difficult time understanding, and that is emphasizing by slowing down the pacing as opposed to speeding up. When people get nervous, there's always a tendency to just try to rush through it and get it over with. That's a great way to lose jurors as opposed to capture their attention. And you figure that out. That takes a lot of trial lawyers, a lot of experience to learn. So congratulations on that. Lily, you touched on one of my favorite expert lines of cross-examination of all time. That is that you, Mr. Expert Witness, charge more to testify about your expertise than to actually do it. Great catch and well executed. You demonstrated great command of a tough witness. He fought you and struggled against your control, and you reeled him in. So nice job. But while that was a highlight, frankly, the whole trial was a highlight for me. This was very professionally done from start to finish. And I could talk for hours, but I don't want to do that because I know you've got things you're trying to move on to. So I'll turn it over to the panelists. Elizabeth, you're just first on my screen, so I'll turn it over to you if that's all right.
Okay, I'll keep it quick. I know that you guys are probably tired and want to kind of move on with the day, but first off, congratulations. I know that you guys have all worked so hard for so long on this case, and it really shows. That was just phenomenal. I really am proud of all you guys. And I wanted to mention, I think I said something similar to the teams that I observed yesterday, but just how well you guys have mastered this whole Zoom technology, showing the exhibits. In my work, I coordinate volunteer attorneys for pro bono cases, and we do these trials through WebEx, and all of this today went more smoothly than some actual hearings that I've seen. So great job on mastering the technology. This is going to be around for a while, and you guys have a big head start on it.
Nate, you want to offer any
Yeah.
thoughts?
Again, just we'll keep it short and sweet. Don't want to keep you all too long, but congratulations and great job. As a 3L law student right now in law school, I was in y'all's position not too long ago in high school doing similar types of things. But I want to say, like, you all have a really great command of like the very beginnings of evidence. Heck, I'm in the class now, and it's been a good refresher just listening to y'all work through the hearsay exceptions, 404, all that. But just want to say good job overall, and I guess just keep it up. Like, it's just one step here now, but y'all, like, I've done the Zoom experience for trials, being a witness, whatnot, like even as recent as last semester, and there's not too much of a drop off in talent from what y'all are doing now to that. So just know it's all very attainable, and y'all are on the right track. And glad y'all went through this, and glad y'all had us as scoring panelists, and everything else.
Thanks, Nate. Heidi, any thoughts? Drum.
My mastery of Zoom isn't quite complete. It was a treat to see all of you, and I don't want to single things out because there were so many good ones, but one thing that really stuck out to me was the civility and the courtesy that you displayed to one another and to the court, and that keep doing it. And congratulations to all of you.
Terrific. Well, best of luck to all of you, and I will leave you with what has been a tradition, that at least in the bar in which I practice, when a case gets finished, and that is even to the opponents, I'll express best of luck on your next trial. So with that, good luck, and congratulations on your